right, everybody, welcome. Justice is a Process, live coming to you with a final wrap up. Well, might be not final wrap up, but we're going to talk about the Jennifer Crumbley verdict. My thoughts on it yesterday. Obviously, I was very shocked, but we've heard now from the jurors, or at least one juror, the four-person, and she shed a little light on what the theory was, and it's actually quite interesting. It kind of changes a little bit my thought process on at least what they were trying to say. It's a shame that's it's frustrating that the way they came to a verdict. But it's also good that they were not swayed by the issue of foreseeability. In other words, I had discounted, and I believed it was discounted, that she had any responsibility for the firearm. But the good news is the jury pretty much, for the most part, rejected the idea that the parents are responsible for, that she was responsible for removing him from the school. That wasn't the issue at hand. Now, at least it doesn't appear. It appears this really came down to comes down to Occam's razor. The simplest explanation is the easiest for this jurors, and what it came down to is, and this kind of shed light on why they asked the question, is they looked at it in two ways. There was the complicated way, which the defense in their eyes focused on, and that was Jennifer Crumbley is in the principal's office and she doesn't take her son from school. And was that sheet that she had in front of her, was that enough for her to think her son was about to do a school shooting? Or is it as simple as this? She was the last adult, allegedly, to have had responsibility for the firearm, at least, that was officially known, because 3 days before she's seen walking in, she said she left it in her car. And in their eyes, that wasn't responsible for her to leave it in the car, and that allowed him to gain access to it. And their reading of the manslaughter law was that if she does a lawful act, which would have been storing it in her car or putting it somewhere, and that would be viewed as reckless and led to Ethan Crumbley gaining access to the gun and then going and doing a shooting, they found that was enough, and they convicted. And the issue here, I think, ultimately, and we're going to watch the clip here of the juror as she speaks, but the interesting part about this is the juror, ultimately, hold on here. The juror ultimately said that really Ethan Crumbley saying they weren't responsible, Ethan Crumbley wouldn't have had any impact on this. And that essentially, it sounds like there was a juror or two in the back that took over the deliberations, and said, listen, it's simple. We're allowed to consider two different theories. And one theory is, did she secure the firearm? The other theory is, is a little more complicated, and it says, hey, did she think that, even if you think she wasn't responsible for securing the firearm, did she know he had access to a firearm, and did she not do enough to leave the school? And it seems that they rejected that. That was not the basis for the verdict. So very interesting. But I think it also speaks to the idea here that this attorney, the more I've thought about it, the attorney in this case, I think her specialty is sexual assault cases. Her specialty is not these type of cases. And I think what happened in this case is she got overwhelmed. She got tunnel vision. And ultimately, she didn't address, and we're going to talk about what she didn't address, because this jury still should have come to a not guilty verdict. But it's going to become clearer to see why they feel this verdict was supported and exactly what some of the other jurors, I think, ended up coming to their own conclusion. They ended up with, it sounds like, a theory to the case that not even the state was arguing. It was like the state had, appeared to be in a weak position, but this jury turned this case into, actually, when you look at how these jurors were seeing the case, beyond a reasonable doubt, I can't necessarily say, but it's quite interesting to see how they saw this. And then I think I could see how in a jury room it just took off, and then one by one the supporters ticked away to where they probably got it down to one or two. And then it sounds like, according to this foreperson, she took it upon herself to make the arguments on behalf of the jurors or whatever camp she was in, and began making the arguing. So let me get to some comments. First off, hello, yeah, and crazy juror comment, yep. So let's see here. Based on how they found, I feel it was James. Yeah, well, potentially, and I'm going to talk about that. Yes, I think, but here's the thing: it doesn't alleviate James, because the theory they used to convict Jennifer. Remember, Jennifer says, and again, it depends on what comes in at trial, but remember, Jennifer was saying James had a responsibility to go get the gun and secure the gun in the car. So if James knows that gun's being stored in the car, he's just as guilty. And him being the gun owner, it doesn't alleviate his guilt. So the theory that the jury used to convict her still doesn't allow James off. In fact, if I'm James's attorney, I'm negotiating a plea right now and saying, what are y'all willing to put on the table? Because, if this is how the jury interprets it. Now, at the same point, I think a good attorney could absolutely, an attorney that has experience in these type of cases, in terms of is more prepared and ready to go and not overwhelmed at trial, I think could very easily deal with this. But I thought it was, I think everybody did. And I think people were really hyper focused on the idea of foreseeability. Was this foreseeable? Did it make sense that when she was called into the school, because that's what we all got drug into. But the issue that we missed when we're looking at this, or the thing that was being missed by a lot of people, was the issue that there were two theories of this case. And that's why that wasn't dealt with appropriately or enough. And that was the issue here, I think, in closing arguments, that I was saying, what in a case like this, where even when I was listening to the jury instructions, it was difficult. It was very confusing to figure out, how do you deliberate? How do you decide this? So what we needed here was the defense attorney. I don't really think had a lot of familiarity with this area of the law, because, again, remember, she was Larry Nassar's attorney. Her specialty, if you go to her website, she's a very good attorney, right? But she was out of her element. It's like what happened to Mike Tyson when he goes and is being tried for, the offenses he was, and he brought in a white collar business attorney. Well, that white collar business attorney put on a defense that just was not the best strategy for the type of crime that he was in, or that they were doing. And had Mike Tyson had a different attorney, many people feel the outcome could have been different for him in that trial. But he hired Don King's business tax attorney, the guy who handled all his tax problems. And in this case, she did the opposite here. She hired an attorney who's a, bulldog attorney, badass of the year, but her specialty is sexual assault. And then when you get into the complexity of a case like this, you needed to have an attorney that fully understood the law, how it was applied, what was going on here, and that they needed to be able to get in front of that jury and make sure they could break down how the deliberations worked. Well, I think so, but here's the issue. This juror honed in on the fact that she left the car, that the last provable point of where the gun was at It wasn't so much who owned the gun, it was the fact that she took him to the shooting range. And then when she gets back from the shooting range, she says, I left the gun in the car, hidden wherever she hid it in the car. And I was going to let my husband go secure it because I don't like to handle it. Now, that sounds, hey, yeah, that sounds plausible to me. Like I said, well, that was 3 days before. Nobody's worried about that. I just took it for granted that the jury would take it for granted that the husband went out and got the gun out of the car. But the problem is that the way this jury viewed it is they didn't view it that way. The way they viewed it is that James is this irresponsible doofus. She doesn't trust James to do anything in his life. She doesn't trust him to cut the grass. Yet she gets home and she says, "All right, James, I'm going to let James worry about the gun." And she does this, and she goes on about her life. But James, being the irresponsible person that he is, never goes out and gets the gun. And in the juror's eyes, this is what gives Ethan access to the gun, and the parents are none the wiser. Now, this is where you get into the definition of negligence, and they say, "Is that gross negligence?" It is, I guess. If you have a son that's homicidal, now that's where the attorney would be able to get in and say, "Well, that might have been negligent, but did it rise to the level of gross negligence?" Because she would have had to have had an idea in this case that her son would be wanting to go intentionally. This wasn't an unintentional act. This wasn't Ethan picks the gun up and he's looking at it and his friend's over and he shoots his friend. And this is the issue, the nuanced legal issue here, that in order to get to conviction in this case, and this is what an attorney needed to really stand up and say, is there's a difference here. Is the theory in this case is not an accident. So if it was an accident, yeah, they would be found guilty under this. The issue that went before the appeals court, and the issue in this case is that in order for them to find, because Ethan finds the gun and goes and takes the gun and shoots somebody. Like, let's say he goes in and finds the hiding place. I mean, parents could have hid this thing anywhere they could have, and he could have gone in and hid it and been watching and been a conniving kid. That doesn't make the parents guilty in this case, because he is doing an intentional act. And the law says previously, normally, when applied in this way, is if there is an intentional act and he is intentionally going in and he is an adult, in this eyes, state says he's an adult, and he goes in and he intentionally finds that gun, takes that gun and shoots it, their culpability is out. He took the responsibility himself. Okay. So the issue at hand here is that a defense attorney needed to make sure that the problem here is it was distracting. So Shannon spent a majority of the time talking about what went on in the school because she assumed, as we all did, that the big focus in the case of Jennifer Crumbley, because she wasn't the gun owner, that it was going to be all about what happened in that school and her decision to let him go back to class. And it turns out the jury didn't care about that, because that was the weakest for them. That was the weakest part. And what happened is the state strategy worked. Jurors wanted to convict. There was some jurors in that room that wanted to convict, and they were able to get a theory of guilt that they were able to sell better than what was sold on. Because what was happening now, what I realized was happening, and what we saw is when this deliberation started, as this foreperson said, they were well represented. There were people digging in. Hey, there's no way. I don't believe she would have done that. But what ends up happening is they said that doesn't matter. And that's why that question comes out and says, is part one enough on its own, or is part one part of part two? In other words, you got to find part one, and then you got to also find part two to be true in order to get conviction. And the judge went back and said, no, it's you can find one or the other. And that's when this whole thing starts to fall apart. That's when within a few more hours of deliberation, that's when they start to say, you know what, all of you people with the theory of, I don't think she knew, I don't think she, I don't think, I don't think she would have ever thought her son would have done this. They said that doesn't matter. The only thing that matters is did she have any responsibility for that firearm? And since she was the last person to take him to the shooting range, she created the access point for the firearm because she stored it in her car, didn't take it back in the house, and didn't store it. Then on top of that, the consciousness of guilt now comes into effect. And they say, in corroborating this is the fact that when she reacts at the police station, she is a little wishy-washy. She doesn't say, "Oh, James had it stored." She says, "Oh my God, the bullets were stored. I had it hidden." There were times that when she was speaking, and then and then she's telling Minash or Malash, Jeff Malash, that, "Hey, I had the gun in my car," meaning indicating she still thought that gun was hidden in her car. She never took it out of her car. So in the juror's eyes, if she's got it in the car and Ethan was in the car and would have seen where it was and she didn't take the time to remove it, and then she comes back and says, "Well, I told my husband to remove it, but but of course that's after the fact." Now it looks like, of course, who's the one? Now they play the video. Who's the one that says we need an attorney? Jennifer. So now they say, well, why is that? And again, this is why I question whether that should have ever been played, because her assertion of that right was okay. And it was a right to do that and shouldn't have been used against her. But they played it, so it looked like she had a guilty mind. Oh my God, I knew I left that gun in my car, and I knew shit, I'm going to be in trouble. And then it goes on further where she's saying, I had it hidden in my car. I had the gun lock on it. And it turns out that wasn't true, because when the police come home, the case is laying on the bed when the police come in and discover it. Now, for me, I took that to mean the dad raced home and says the gun's not there. Now, to me, and that was significant, because my issue was that, and again, this is why the attorney didn't focus any time on this, because the reason why I dismissed it was because the dad, in the text messages, which she's then, in all of these things, I take as credible, because at that particular point, she's just sending messages out, and it's all just part of the state of mind that she's in at the moment. But it's clear the dad's messages to her are, the gun's gone, the bullets are gone. Those are verifiable messages, meaning that gun case was at the house, meaning it had been brought back in the house, meaning that her leaving it in the car for the dad to bring it inside, that was no longer an issue. But the jury didn't feel that way, because the way the jury looked at it as is, well, the dad could have been covering up for the mom, and that's why the mom's asking for an attorney, and that's why she's saying we're fucked. That's why she's saying we're getting the hell out of town. That's why she's getting money out of the bank. And again, when they're in the jury room, right, there's been no argument on it. There's been no addressing of the issue. Majority of the closing argument was addressing the issue. And the jurors in there that wanted to find her guilty because they were angry at the fact that these kids died, they just scooped that right out and said, "Yep, guys, your argument doesn't matter. The argument of foreseeability doesn't matter." But it actually does matter, right? It did matter. And what does matter is the fact that an attorney should have stood up there and should have been focusing on both, and they should have had a board up. So there's two. There's two. But when you listen to Shannon's closing argument, which I went back and reviewed again with this new information, part of the reason why I was so late on getting all this out is, once I went back and reviewed it and started listening to it, I'm like, that wasn't covered adequately. It wasn't covered clearly. And what was a majority of the closing argument was about talking about her making the decision to leave her son at school, which clearly was very strong and clearly wasn't part of why they decided to convict. All right, so let's play. I'm going to play for you. Of course, I've talked a good bit, but I want to play for you the this juror's interview, two interviews, in fact. And let me let's see here. All right.
Tell us how it was deliberating.
It was very difficult. It wasn't an easy decision. Lives hung in the balance, and we took that very seriously.
And tell us, did you have to convince each other? Is there anything like that where it was going maybe?
I will say both sides were well represented.
Oh, okay. Tell us how it was deliberating.
It was very difficult. It wasn't an easy decision. Lives hung in the balance, and we took that very seriously.
And tell us, did you have to tell us?
All right, guys, apologize there. I had a little technical difficulties getting this up, but this is an interview that the foreperson of the jury. She did this interview out at front of the courthouse, and we're going to watch the one that was the national interview that she did. But I want you to listen to what she had to say about this verdict and what went into the verdict. So let's listen here.
Oh, okay. Tell me your name.
Nope.
You don't want to tell your name? That's fine. That's fine.
You confirm you were the forewoman, though?
I was the forewoman.
Okay.
Was there something specific that really stuck that you guys were debating over for that many hours?
The thing that really hammered it home is that she was the last adult with the gun. And that's where I'll end my comment. Thank you.
So if you had heard from Ethan, would that have changed anything?
Thank you. Tell us how it was deliberating.
All right, so there you have it. Not much said in this except for that what hammered it home was she was the last adult with access to the gun, and that is not true. That is not supported by the evidence, but clearly the jury didn't realize that. Because the way the jury interpreted this is 3 days before she takes Ethan to the shooting range, and they focused on some things, I guess, that they believed strongly that was the case, but it wasn't the case. And again, what should have been made clear to the jury, and I took for granted that it was because it was made clear to me, is the fact that the dad couldn't have been texting and wouldn't have raced home to believe that the gun was at the house if he didn't believe the gun was already brought back into the house and secured. So as a result, then, the culpability for Jennifer Crumbley is gone. So this issue that they convicted on, the good news is they did not believe the other issue. It wasn't strong enough. It didn't carry the day. That was the not guilties. The not guilties were, we don't believe she would have ever known that. We don't believe that that she could have predicted that this would have happened, and as a result, when she was at the school and let him stay at the school, that was somehow negligent parenting or gross negligence or rose to the level of negligence that you would have looked at that sheet. They dismissed that. And they dismissed that because I think it was probably pretty strong evidence with the fact that you had two educators and a counselor sitting there. But what they didn't dismiss was the fact that she took him to the shooting range, put the gun in her car, and in the eyes of the jury, left that gun in the car where they believed he got access to the gun. But that's not true. Okay. Now, and again, think about it in that jury room, right? Evidence is they locked him out. What they're thinking in their mind, right, is these parents lock him out. He goes outside. He has access to her car. He goes into the car. He gets the gun out. He gets the bullets out. He sneaks it back into the house, gets it in his book bag. Mom, dad are distracted with life, whatever. They have no idea. They go and go on about life. Then they get called to the school. He's drawing this picture, and they're none the wiser. They don't, in the eyes of the jury, they don't have to foresee that he's going to do a school shooting. But here's the issue. They actually did, and we're gonna put the statute back up. But this is where there was some lack of clarity because it was up to the defense attorney to really make clear what they needed to do here. But they thought, well, access to the gun. He couldn't have had access to the gun without her having stored it in there. She should have taken it and stored it away. And yes, in an accidental situation, that would have been enough. But that's not what was enough in this case. That's not what the appeals court held was enough in this case. And that's not what the jury had to go to. But that's what she just said. And again, we'll play this one more time and then we'll get to the national interview. The part that hammered it home actually is not enough. So I hate to tell this juror, they still did not make the correct verdict if what hammered it home was access to the gun, because the mere access to the gun was not enough. They had to believe there had to have been a belief that that the allowable access to the gun, in other words, her just storing it in the car and him getting access to it, is no different than if it was stored in the house. There had to have been an ability here, which is why the part to the school was so important, which is why it was a very confusing thing to have the instructions the way they were. And I don't think the defense attorney spent enough time explaining how to handle those instructions. And then you get this result here. But here, let's just listen to it one more time.
It was very difficult. It wasn't an easy decision. Lives hung in the balance, and we took that very seriously.
And tell us, did you have to convince each other? Is there anything like that where it was going maybe?
I will say both sides were well represented.
Oh, okay. Tell me your name.
Nope.
You don't want to tell your name? That's fine. That's
You
fine.
confirm you were the forewoman, though?
I was the forewoman.
Okay.
Was there something specific that really stuck that you guys were debating over for that many hours?
The thing that really hammered it home is that she was the last adult with the gun. And that's where I'll end my
And there's the fundamental misunderstanding here, that just being the last adult with a gun was not enough to get to a conviction here in this case under the theory that needed to be done. Because like I said, if it had been an accidental situation, yes, but in this case, but because there was an accident that occurred and he has the gun and he mishandles the gun. The issue here is that when he goes and does an intentional act with a gun, the mere access to the gun for him to do that, just him accessing the gun or having figured out it was in the car or hidden in the car or whatever, is not enough in this case to alleviate his intentional act and his own, what we would call gross negligence, but his own intentional act. Because in normal cases, the causal link in a case like this, when you go commit an intentional act with the firearm, now he owns that entirely. The whole issue here was they believed that the jury would have to make a finding that they allowed him to have a gun, knowing that he was mentally incapacitated to the point that he would have wanted to do a school shooting, and that it had to have been reasonably foreseeable that the risk was apparent that he was going to go do a school shooting, and that they did not take steps to take the gun away from him. So the misunderstanding here of this young lady is that the mere fact that the gun was present, it was enough because he was a child. But the issue at hand here is that like I said, that would have been the case that an 8-year-old child gets a hold of a gun and shoots his little sister or shoots his cousin or shoots his friend. But that's not the case in this act here, especially in the fact that the state went and charged him as an adult. And as a result, he committed an intentional act with the firearm. So that does not automatically say, just because she made the gun accessible, that she would be guilty of involuntary manslaughter. That's unfortunately just a misread of the law, but it is what happens when jurors decide, I want to convict, and you get the individuals back there who are just so upset with her, and they say, they were trying to figure out a way around to argue against the people that were saying, well, this wasn't foreseeable, this wasn't it. And their read is that foreseeability was not a factor in the other side, and it actually is. Now, let's take a look at her appearance on a national broadcast here. Give me a moment.
Tell us how it was deliberating.
It was very difficult. It wasn't an easy decision. Lives hung in the balance.
Apologize there.
The jury foreperson in this first of its kind trial is with us now. Alex, good morning to you. We're not mentioning your last name for your own privacy reasons. I have to say, to have you here, it's a privilege, because what we ask jurors to do in this country is really, really difficult.
Very difficult.
To sit in judgment of their fellow citizen, and that is something that you and your fellow jurors did. What was it like in that courtroom, having that responsibility and delivering that verdict yesterday?
There was definitely a weight. I think anytime we entered the courtroom, there was an undeniable weight on us. We all took the responsibility that was put upon us seriously, and I'm just one of 12 that made a very difficult decision.
What was the evidence that swayed you in the end? You said it wasn't an easy decision. This wasn't a
Not
slam dunk.
easy at all. So speaking for myself, I know that each individual juror had their own opinion. This did this for one person, this convinced the other. For me, I just feel like Jennifer didn't separate her son from the gun enough to save those lives that day.
You felt she was the last person known to have had.
Okay, so I don't think it has to be said. Maybe it shouldn't be said, but anytime you have a juror who has to hesitate that much, there's reasonable doubt there, right? She had a reasonable doubt there. She couldn't even figure out why she gave the verdict. She can't even put it into words. She said she didn't separate herself enough from it. And reality is, what she's basically saying here is, I know my verdict wasn't supported by the law. I just decided, I was swayed. I think she might even maybe have her own questions now when she comes out and looks at this. But the bottom line is that's not a very that's not what you would expect. That's not no vacillation or wavering or unwavering. She said she didn't separate him enough. But the issue was, there wasn't an obligation. She didn't say the key words. She didn't separate her son enough, knowing that he was a threat, knowing that he was a potential school shooter. She says she didn't separate him enough to save lives. Well, again, the issue here, as taking the other interview into account, the issue here is, well, you know, what could she have done to separate him? You know, and I guess it was not have the gun in the car. I mean, this answer makes no sense whatsoever, because there wasn't an obligation to separate him from the gun if he didn't have the gun. So how did she not separate him enough? She didn't know he had a gun? Is she saying she thought he had a gun in the school? So again, knowing the previous interview that we looked at, we know it has to do with her being the last person. Apologize. So we know she was the last person with the gun. Now you see Savannah Guthrie kind of walks her into that answer and says, "Oh, so you're saying that was the last adult?" I mean, even Savannah Guthrie, you can tell, is like, "What are you saying here?" And well, let's listen to the rest of what she says here.
Custody of the gun.
Yes.
And then somehow it ends up in his hands.
And I think the responsibility of securing the weapon then falls on her.
What about those text messages or journal entries or things that the jurors saw where it indicated that Ethan had asked for help and that his parents hadn't given him that help? Was that persuasive to you?
To me personally, it wasn't as impactful as the evidence of her having the gun. But I know for my fellow jurors that the notebook played a huge part.
Tell me about her testimony. It's
So, wow. First of all, Puel's attorney's got to love that, because that notebook was very questionable to have even come in. It was brought in as it was brought in under a hearsay exception, and he wasn't available to testify. And resoundingly, many legal people out there that have looked at this case have all said that notebook should not have come in, and that this judge erred in allowing it to come in, with the defendant not being able to testify. And that absolutely should never have been allowed into this trial. So the fact that we have a juror on a national broadcast saying, yeah, other jurors in that room were swayed by that notebook, ooh, that's That's good for the appellate process here. However, for her also, she says, I wasn't swayed by it. So what that tells you is this juror has a complete misunderstanding of the fact that of the obligations of what Jennifer Crumbley was obligated to do. First of all, she I guess believes that there was evidence presented, and I guess she failed to see the text messages where why would James Crumbley be racing home and not be racing to his wife? Why wouldn't James Crumbley have texted, Jen, check your car. Check your car for the gun. Is the gun in your car, Jen? That's not what happened. Okay? She didn't say that. He goes home, checks the house, and says, the gun is missing. The bullets are missing. I hid the bullets separate from the gun. Those are text messages that were brought into court. So this issue that she just brought up that says Jennifer Crumbley had an obligation to secure the weapon. Again, not even getting into once you say, okay, she was in possession of the weapon. But the evidence doesn't support what she's saying. So she was swayed because in a moment, this hits, right? And when somebody puts it together and says, listen, here's my theory of the case. Jennifer Crumbley's the last person. It's in the car. Jeffrey Malash, she says, she's telling Jeffrey Malash that that the gun's secured in her car. Now, I don't believe that she told Jeffrey Malash that those were messages, and I have to go back and watch his testimony, and perhaps maybe we will here at some point. But I want to go back and watch his testimony again because it's my recollection that the gun being in the car was part of the messages that were deleted, and that this was being based on his memory, just like he's going to the school to do something stupid was based on his memory, not on what messages that were actually entered into evidence. And if that's the case, then again, are you going to tell me you believe Jeffrey Malash beyond a reasonable doubt on his recollection when it was brought in and he admitted himself he has memory problems? And that this man, when they play snippets of his interview to the police, you can see he is being persuaded to change his story, that he's very easily able to have suggestions made of what was, and that he is clearly trying to, remember what messages were that 3 days before she said she's taking Ethan to the gun range, that he's got all this stuff jumbled up. But to me, you have actual messages that demonstrate that James Crumbley isn't driving across town to check if the gun's at the house if he thought the gun was in his wife's car. It just isn't happening. So, again, we eliminate that. And you see, well, we're going to play this clip through, but you're going to also hear that when she went back to deliberations, I think she might have been one of the not guilties. I think she was swayed by Jennifer Crumbley's testimony at first. And then somebody back there said, oh, no, I got the theory. And this ties it all together. Mommy was, taking the son to the thing, and then she didn't secure the gun, and then she's telling Jeffrey Malash the gun's in the car, and she's saying that there's a lock on it, and there isn't, and then she's the one that tells the police we need a lawyer, and then she's the one sending the messages out to Jeffrey Malash, we're fucked, and she's the one, because she knew she didn't secure that weapon, and she had an obligation to secure the weapon, and yes, she does, to a degree, as long as this is an accidental situation. But when it becomes an intentional act, the level that from the appeals court in the ruling, in this case, that allowed us to proceed forward, the court held that they have to say that it was reasonably foreseeable that he was going to do a school shooting, and it was based on the fact that they would have seen a mental imbalance, and that it was clear, convincing to the parents, and they did nothing about that and still let him access the firearm. That has nothing to do with securing the firearm, and she doesn't address. And for her to say that the diary had nothing to do with that tells you she separated that fact, and thereby the standard that it was needed in this case by her own admission. And I don't know, again, obviously her attorney could be watching this, but she herself, again, she voted guilty, but what she's sharing, by definition of how she's sharing it and her theory of guilt, does it reach the legal level needed for her to have come to that conclusion? She just didn't understand it. And again, it comes back to, I believe this attorney just, she was doing the best she could. She was one person. You saw they had a whole team of state attorneys over there. She's a good attorney. Okay, she made solid arguments on one half. She just didn't foresee that this jury wasn't getting the fact that Jennifer Crumbley had no obligation with the gun, and that first part still requires the foreseeability issue, because this wasn't an issue of an accidental discharge. This wasn't an issue of a kid playing with a gun. He went and did an intentional act with the gun, which changes the interpretation of those events. And her attorney needed to have made that clearer. In analyzing the case, it was clear to me, I didn't think it was an issue. I didn't think this jury was going to go back there and even consider an issue of, did she secure the weapon or not? I felt like that's a James Crumbley issue, as did the rest of the world, except for this jury. But this is what happens when the state inspires a jury to want to find guilt. And there were some jurors back there that were so upset and incensed by this killing having happened, felt inspired to become an activist for guilt and to come out, and they found a creative way to rationalize a guilty verdict. And I don't think these jurors are going to sit back and go, man, I really wish I feel terrible for voting guilty, even if they figure out this is the case, because I think they were just upset that they're like, she wasn't a very responsible parent. And again, doesn't appear she was. But the question is, it's a question of law. It's not a question of that when you get into the courtroom. All right, let's play the rest of this.
Jennifer Crumbley took the stand in her own defense. She testified. What did you make of her on the witness stand?
At the time, I tried to take her as she gave herself. But once we went into deliberation, it became clear that she wasn't a super reliable witness in this case.
Do you think she helped herself on the stand or hurt herself? Would it have been better, in other words, if she hadn't testified at all?
We'll never know.
Yeah. You talked about her testimony. There was a point where she was asked, would you have done anything differently? And she said she wouldn't have. How did that strike you and the other jurors?
It was repeated a lot in the deliberation room. I think that it was very upsetting to hear. I think that there are many small things that could have been done to prevent this.
When you went back into the jury room, you're the jury foreperson.
I am.
Which is a big responsibility. And I should just mention again, there is no manual for jurors. Nobody tells jurors how to deliberate. So how did you handle it? And how was the jury immediately in agreement, or how did it play out?
So I took it more as a job of facilitation. I wanted to make sure that each and every juror, to the best of my ability, was heard and understood and made their point, and we heard their piece. And so that was the role that I took on as the foreperson. It was not immediately unanimous, and it was my responsibility to hear the concerns of those on either side and construct an argument either way.
Do you feel that the jurors wish they could have heard from Ethan Crumbley himself?
I'm not sure how much that would have helped or hurt.
All right, Alex, thank you so much for your civil service. Being a juror is not easy, and this was a very difficult case. Thank you so much.
Thank you.
Appreciate it.
Hey, thanks for watching. Don't miss the Today Show every week.
All right. So there's a little pitch for the Today Show. So yeah, I'm going to go through some good comments here. I'm going to put this as a backdrop though here. Let me let's put this up here. 896. All right. So there we go. So some great comments in here. Yes, it was present sense, and I agree. Present sense exception was exactly what the hearsay exception was. And I don't know what the present sense was, and I think that's why a lot of lawyers out there that I've been watching ran it by my dad. And we were talking about the whole thing, and it doesn't make sense. But I think again, this judge wanted to help in a sense. Wanted to help the prosecution a little bit. I think she feels political pressure, and she didn't want to be seen as doing anything that would hurt this case. But she also, she was incredibly weak. I thought I couldn't believe, the way she allowed the male prosecutor to just push, just literally act as if he was the judge. I mean, he would stand up and say, "This is what we're going to do," and she would kind of be like, "Well, okay." I mean, and it was like, and then Shannon would be over there, and it was like, and he would tell her, he'd stick his hand out and say, "All right, that's it. I'm talking right now. You be quiet." I'm thinking to myself, what in the world? But to answer your question, it is legal. Yeah, I mean, look, this is why Shannon was talking about in the closing statement that yes, it is legal for them to possess at home. I mean, for them to be around. I mean, they take pictures. She was saying they take pictures at their homecoming. And like that's what Shannon was trying to say was, oh yeah, I focus on the dresses or whatever. These girls are focused on their gun. You know, well, no. The only thing the appeals court took up, because the judge actually addressed it. Was talking about it in court in one of the times that the jury was taken out of because there was a section of the journal. This was actually addressed directly by the judge. There was a section of the journal that Shannon wanted to admit. And the judge talked about the hearing when she allowed it in. And of course, Shannon renewed her objection, saying she didn't think the journal should have come in at all because they didn't have the defendant there or not the defendant. They didn't have the son there to testify. And the judge was clear and said, I have not said he can't testify, but I ruled certain portions were in as present sense. And the prosecutor was objecting and saying what Shannon wanted to bring in, which was, she was saying was impeachment. She was trying to impeach the present sense. And the judge was saying, well, I ruled that part in, but I didn't rule in the other. But the appeals court, the only issue the appeals court took up was the issue regarding whether or not the case could proceed under the idea that normally in an involuntary manslaughter case, if the individual does an intentional act, that would have normally have eliminated the culpability of either parent for having not secured the firearm, in the sense that, if they didn't know or know he was going to do a crime. In other words, they would have had to know he was going to go murder somebody and hand him the firearm and said, okay, now they're guilty of murder. But if he goes out and sets on an intentional path and watches his parents hide the gun and goes in and gets it, just because the mere fact that the gun was hidden or they had a gun in their house isn't enough for them to come. And again, this is what this juror was saying. She didn't do enough. She didn't secure the firearm. Well, the issue is okay, if you find that, you still have to find that it was foreseeable, and that the issue at hand was that they could have foresaw that he was mentally unstable and planning a school shooting, and that by her having left that car or hidden that gun in the car, that she should have known she had a school shooter in her house, and thereby she should have been having that thing under complete lock and key, watching the firearm at all times. And that was the craziness of the case. And that was what Shannon didn't do a good enough job of talking about on the two parts. Now, I have the two parts up here on the screen. The part they found here under this is, the part that was talked about was the gross negligence and failing to perform a legal duty. This first part was kind of taken like, it was like everybody just kind of understood, because Jennifer wasn't the gun owner. Jennifer didn't do much with the gun. It really wasn't thought of that this would become basis for conviction, but this is what they ultimately convicted on. The defendant caused death, and that in doing the act that caused death, the defendant acted in a grossly negligent manner. And what they found was that the actions in a grossly negligent manner was failing to secure the weapon. And the problem here is that is not correct. Because the appeals court found that you still have to, even whether it's in performance of a lawful act or failing to perform a lawful act, they still had to have an idea that it was foreseeable that he would have done this. And it was a much harder situation to get to when you say, well, the foreseeable deal was something the jury still had to cross with both of these, because to get to grossly negligent, and let me make sure I find the right one. Yes, okay, there it is. So we move on to the grossly negligent slide. And again, this is coming directly from the prosecution itself. Gross negligence means more than carelessness. So understand what this jury convicted her of was carelessness, right? What that juror's saying is she didn't do enough to separate them. She was careless in leaving the gun in the car. That's not enough. Carelessness in this case is not enough, right? It's a willful disregarding the results that others might follow from an act or failure to act. In order that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. In this case, it was not an accident. And this is what has to be understood. If it was an accidental discharge, then yes, you could say, Ethan Crumbley, she leaves it in the car. She knows he's fixated with guns. He picks up this gun. Buddy's over at the house. Hey, look at my gun, man. Bam, it goes off. Okay. Could a parent foresee that an accident could have happened and that if he gets access to that gun unsupervised, that an accident could occur? Absolutely. And you're in a different situation. And this could get applied all day long, right? Because she didn't take care. And if they can prove that he found the gun in the car, and by his statement, he says, I found the gun in the car, and this gets brought in, boom, okay? But there isn't that statement, right? And you have to know the danger. And in this case, this wasn't danger of accidental discharge. This was the danger that he was going to shoot up a school. So you have to, at all aspects of this, and this is where the defense attorney fell short in this case. She didn't take the time to explain that whether you go version 1 or version 2, you still got to walk through this. She should have walked through gross negligence, but she made assumptions, and she was really focused on, oh my God, it's ridiculous. Would you prefer that a parent would see this? And again, it was all focused on that other one. So the way the jury saw this or back in the back room is, well, there's two versions. And if she failed to secure the gun, she's guilty. No, it's not that simple, because you got to then go in and you've got to make sure the elements of gross negligence are met. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when to let me move myself there, reasonable person, it must have been apparent that the result was likely to be serious injury. Again, this is how that version, when we go back to the two different theories of the case, the two different ways, this is how, let me get it back up here. This is how that becomes a requirement, because the defendant caused death. So you would say they have to find that she caused the death by allowing access to the gun. Okay. Because in general, the storage of that gun or where it was stored doesn't necessarily mean someone dies. But in doing so, acted in a grossly negligent manner. The gross negligence requires her to have foresaw that her son knows that her son was a likely school shooter. She left the gun there. She let him get access to it. If she doesn't think he's a likely school shooter, and if she thinks to herself, all right, I accidentally left it out there, James, you need to go out and get it, that's careless. She shouldn't have done that. That's regrettable. In a civil lawsuit, maybe a jury finds her liable and she gets sued because she didn't handle a firearm. But in a criminal case, does it rise to criminal gross negligence? No. So this young lady has helped in a great big way to show that this jury clearly didn't get it right. Yeah, they were confused by exactly. And again, this comes down to I think, I said in the closing, I think Shannon may have been showing this as a, this was part of her defense, and perhaps it was just to show that you can make mistakes, you can be. But one thing became clear, and again, I never, it was never addressed. Maybe someone heard, maybe I missed, but there was a gentleman that was helping her, and he was sitting there for like 2 days at the defense table, and then suddenly he was gone. So I don't know if he left because he was so upset with what was going on. I don't know if he left. It seemed he left after she made her comment about unaliving herself. and she was going to go home and drink 5 glasses of wine, and it seemed like he was gone. So I don't know if he left and said, I just can't be associated with this defense. I don't know if that really just speaks to how unprepared she was and how overwhelmed she was, because again, it appeared she was struggling to get through discovery. She was trying to make a case to the judge that this state attorney's office had unfairly bombarded her with information, and she wasn't able to get through it all. But it was clear to me that she didn't understand, that she was running at the seat of her pants. So I thought, well, maybe that was just an act. But now, looking back, seeing how this jury interpreted things and understanding that, I was concerned, but I really felt that this jury would have, just like me having sat and watched this case from opening statements to closing arguments, I thought it was self-evident that the dad eliminated this. He was okay. So he was just there for a specific issue. I can't remember what it was. Okay, gotcha. I wondered what happened to him. But I thought it was just evident that the text messages between mom and dad, and I think that's probably what Shannon thought too, but I think that it needed to really be understood. And that was what I was concerned about, especially when, in this case, and I guess other states do it. In West Virginia, they read the instructions first and then they do closing arguments. In the Tyrone Tucker case, they did this, although I thought that was just because it was there was some confusion over some things that were going on, just because they weren't expecting things to conclude when they did. But in my opinion, this was also the result of the jury instructions get read after the closing, and it takes away the ability for the defense attorney to be able to help incorporate that into their closing. Because when you have a case like this that is extremely confusing, because when I heard the instructions myself, I was like, whoa, okay, this is a bit confusing. And to not have the defense attorney be able to say, hey, boom, 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 boom. But you see what the state did here is the state took portions of what they expected were in the instructions and included it here. Because this slide I have up here is from the state. And they walked through and they said there's 2 versions. And you can very easily look that if you're not understanding, and these people on the jury don't necessarily have the experience on how to apply the law. They don't have people to ask questions to like I do. They haven't been around it for a long time. Probably haven't served before in a jury. And they're looking at this and they go, okay, acting to their idea, their definition of grossly negligent is they didn't secure the firearm. They didn't go deeper into grossly negligent because they weren't told to. So they look at this and they go, okay, theory 1 has the legal duty. So for them, that's the legal duty to get him help. That's the legal duty to deal with the fact that he might be a school shooter. And then there's part 1 that just deals with a grossly negligent act, which that must be to secure the firearm? Yeah, okay. So if we believe she didn't take steps to secure the firearm, and then everybody in that room that's over there say, well, yeah, but it wasn't foreseeable. They're being told you don't matter. When it actually does matter. Because in order for them to find gross negligence in this case, it is not just simply you didn't secure the firearm. This isn't an accidental situation. You have to go to the level of saying they had to still think it was reasonably foreseeable that the firearm, that he was going to be a school shooter. And that's why with James, it is still not, even in this case, the jury finds it the way they did. It is still not a slam dunk for James because they still have to say that he believed his son was a school shooter. So even if he doesn't secure the weapon, this isn't an accidental situation. Even if you don't like the fact he didn't have it in the case, he stored it, he hid it. And that's what he's going to say. He's got text messages that shows he went home. That's going to come out. He didn't ask for an attorney. He was willing to talk to the police. So even if that tape gets played, it doesn't look like it did for Jennifer. This jury felt she had something to hide. This jury felt once they start rolling with this theory Now they start taking all the pieces and putting it together. She's got something to hide. She's leading the way. She's getting money out of the bank. She's getting burner phones. She's saying we're fucked. She's the one saying all these things. And James is, and she's the one in handcuffs in the car. I mean, and again, like I said, the attorney didn't address those issues. You know, if this attorney would have taken the case and been ready to go, and imagine what the outcome could have been. Yep. Excellent. Thank you, Angela. And actually, I'm going to be going in. That's going to be my next deal, is to cover the Adam Montgomery case. So we'll be so check back over on that too. I'll be covering that as it goes. That's the next case I decided. I was considering a couple cases and decided that one. But anyways, back to the discussion here. So, you know, that's the issue here. You know, and that's the problem that we have. The continuous issue that we have with this case is that we had a failure to really address this thing. Well, she did, but see, what I wanted addressed. Here's what I wanted addressed, right? What this jury needed was they needed to see this case in the sense that of what was going on here. So my theory of the case is that these parents, this case should have never been brought. That should have been what she's saying. This case should never been brought, ladies and gentlemen of the jury, because this case was brought for one reason, because they didn't like Jennifer Crumbley. They didn't like her, and she pissed them off. And she pissed off the police because, and play the tape, the tape of them in that room at the substation. And James is starting to talk, and she says, "We want a lawyer." The moment she says, "We want a lawyer," that room goes to negative 30 degrees. Those police officers get upset. They start explaining that we need to talk to your son. Are you serious? You're going to do this? At that moment, she becomes the enemy. Not only does she become the enemy, and you might say, well, okay, you're being conspiratorial. Am I? Well, okay, maybe if that's all we had. But what we do have is we have them going in. We see their son. We see the time. We know the timing of that is about 2:25 in the afternoon. 20 minutes later, they arrive at her house. James Crumbley is put in a backseat of the police car. No handcuffs. Jennifer Crumbley is cuffed, put in the backseat of the police car. You are not going to tell me that's a coincidence. That the individual that asserted her son's rights, the individual that stopped the conversation with the police, the individual said, "We aren't cooperating with you," is the one that gets locked in handcuffs in the back of the car. On top of that, they start going through her phone. Now, they're looking at things, and of course, they see some of the comments. They see, you know, as they're interpreting, and, you know, again, I'm not exactly sure at what point they got all of the messages, because some of the messages came from the burner phone after the fact, but they at least got some of the Jeffrey Malash statements. So as a result, you know, police again start making their case, and they're making their case against Jennifer Crumbley because they're mad at her, and they're pursuing her, and they're pursuing him because in their eyes, she was the one that got in the way. She was the one that had the audacity to assert her son's rights, assert her rights, and say so. And then on top of that, they're going to be immediately suspicious. And then they start seeing some things. They provided him with a gun. They see the journal. They see these different things. The problem is yes, look, I am not sitting here and saying that Jennifer Crumbley was a great parent. I'm not at all. Clearly, she missed signs. Clearly, she had selfish parenting. Clearly, she was not the poster child for a parent of the year, right? But what I'm saying is that's a far cry. That is a far cry from saying you're criminally negligent in causing a homicide, first-degree homicide, school shooting. Well, yes, the DA does make that, but my point is that the police drive the investigation. The police start targeting her. The police start to turn this investigation on her in a manner that then drives the conversation to, hey, we have these parents that are doing these things. And then, of course, obviously, yes, the DA gets in there and saw a political opportunity. They saw an opportunity here where they said, you know what, again, if these police officers would have come back to them and said, come back to the DA and said, yeah, these parents had no idea, there's no way. But that wasn't what they were saying. They're saying, we are suspicious of this woman. There's something going on with her. She's a bad egg. And they went after her. And once that got rolling down the road, once the press gets wind of it, once all eyes are on the Crumbleys and they've decided, you know what, we're going to go after this person. She's, again, there was a lot of assumptions made, and this is what can happen that leads to, remember, she was charged within a couple of days. They didn't have to charge the parents right away. But she, they didn't have to charge them right away, but they started down that road. They started down that road of, we have an opportunity here. And again, it was a matter of, they didn't like what they found on her phone. They didn't like who she was. They didn't like the fact that this kid's in the journal saying it's because of my parents. And because the parents didn't take the time to assist the police immediately took, as many times do. Again, like I said, the idea here from the police officers was, if we need to send a message loud and clear. If you decide when your kid shoots up a school that you're not going to cooperate with the investigation, well, you might become part of the investigation. And that's exactly what happened here. And now, not only does she become part of the investigation, she's now become convicted of involuntary manslaughter 4 times over. So, any parent watching that now would absolutely be like, wow. Because if you look at her, although I'm not putting her up for parent of the year, I'm also not suggesting that I don't think she was some horrific parent. I don't think she was any different, like Angela just said here. The things that were going on there, I think, are very similar to what many parents would experience. And none of them would have thought Ethan Crumbley was going to yeah. Well, again, I think that was part of, obviously that was things they saw in the text messages, and I think they created an idea that she definitely was not paying, being in their eyes a responsible parent. And then they put a gun, son has access to a gun, and we get here. But the problem is, again, is the application of the law. And there has to be an explanation. Why did they go forward with this case? I think that's why they went forward with this case. And you may think, no, they wouldn't do that. Well, they will do that. And that's, and again, the tell in this, and the explanation that was never given, and it wasn't even addressed in court. And Shannon maybe didn't ask the question because she was anticipating she couldn't control what the answer would be. But the big tell is, I'm telling you, the tell is the fact. Explain, why did she and not the husband end up in handcuffs? Well, absolutely. In fact, I was having that conversation with my son. I said, listen, with the way they applied this law, I said, it can have everything to do with, like I was giving him an example. I said, listen, don't be surprised now. I'm going to make sure that, I've got protocols on your music. We have Apple Music. And I said, he was complaining to me because I don't let him do the explicit, lyrics. I keep him uncensored. And, he's always talking to me about that. And I said, don't be surprised if you don't get now the explicit taken off until you're 18 for certain now. I said, because there is no such thing now as any type of cool parenting move. I said, because with this case here, with the way they applied it, if you go out and do something stupid, you go out and do some intentional act, not saying you would, I don't think you would, but let's just say you do, and somehow it comes back and they say you listen to violent music. And a prosecutor gets a hold of that and says, I knowingly allowed my son to listen to violent music. And then allowed him, and then he goes out and at his grandparents, I knew he might have access to a firearm. And as a result, he goes out, grabs a firearm, decides to emulate one of the songs he hears, and gets into a gunfight with his friend or something and shoots a friend. Now, police get a hold of our phones. They might have a right to have a search warrant for the phone and come in and say, hey, I want to search your phone. I want to search your son's phone. And they see that, hey, my son was listening to lots of violent rap music. And then they see that I, as the parent that was in charge of the Apple accounts, cleared that and didn't put parental restrictions on it. And they would say, well, wouldn't it be reasonably foreseeable that you would have thought that your son listening to violent rap music, and then they go in and look at his video game and say, hey, you let your son play, this Fortnite that had violent, guns in it. And then you should have known that a grandparent, didn't he go over to his grandparents' house and he had access to a gun? He could have stole the gun there, and they take this before a grand jury and put it in there, and suddenly I'm indicted, right? The message here to parents is you are now responsible for a lot. Like, there is no cool parenting. Stretch it out to, a parent that says, I'm going to let my kid drink. I'm going to let my kid, do this or do that. And they think, well, it's my kid, my house. Not anymore. If this kid goes out, I mean, again, right? Taking the reasonable foreseeable definition here, child. There are some parents out there, not mine. I'm not one of these, but some parents out there, or at least I recall being told, well, I know, in fact, I know one of my son's friends told me that my oldest son, when he was on the football team, one of the kids there, stayed home on homecoming. And they said, well, why is he at home on homecoming? He said, well, because his dad lets him drink at the house. And I said, man, that's crazy. Well, right. That's what I'm getting at here. This is how it could happen. So son starts drinking at the house, right? And as a result, now, doesn't mean that the parent said, I'm going to allow him to drink on the night that this accident happens, but it can be shown that this kid develops an alcohol problem and it starts drinking to excess. So kid's out, staying the night at a friend's house, and begins drinking and gets behind the wheel of a car. Parent has no knowledge that he's getting behind the wheel of a car or that he's doing any drinking on that particular night. But he gets in there, wrecks the car, DUI with death, kid's charged. They pull the kid's cell phone. In West Virginia now, cell phones are getting pulled anytime there's a car accident because there's laws on the books to that effect. But they see in there that there's talk of this alcohol problem. There's talk that the dad was allowing, or the parents were allowing, this young man or young lady to drink at the house. They would say, it's reasonable foreseeable, first of all, that allowing a minor to drink could develop an alcohol problem. You are responsible, for ordinary care of that minor. Because that minor developed the alcohol problem, which now led to this individual getting behind the wheel, the parent should have foresaw that someone with an alcohol problem was a higher probability and a higher risk to get behind the car. You bought that minor and allowed that minor to drive their vehicle over to their friend's house. Now, you didn't know he was going to drink that night. You did know for certain. You didn't provide the alcohol to him that night. But you should have reasonably foresaw that your child, who you've allowed to start drinking at your house, and had developed signs of potential over drinking, which is, we have text message A, text message B. You're drinking too much. You need to stop drinking. What are you doing? Stop. You should have taken the keys and restricted them from ever driving an automobile, because it was reasonably foreseeable that a minor who should have been drinking, who was allowed to drink and develop an alcohol problem, and you as a parent responsible with a legal duty to care for that child, had a legal duty to the individuals that died in that auto accident. As a result, you can get charged with involuntary manslaughter under the theory that this prosecutor used. Little convoluted in what I described there, but that is essentially what they charged here, basically meaning that the parents have to be have to be cognizant at all times at what is potentially a foreseeable outcome, and that we as parents must. This case is essentially set up the idea that we as parents have a legal duty and requirement to assume the worst of our children, which is not natural in parents, at least in my opinion. If you have most parents naturally would assume the best in their child, and sometimes parents are the worst when you're bringing them in and saying, well, in this case, because if you read here, it says defendant had a legal duty to the victim. The idea here in this case was that to get to this case, the way it was done, is this jury had to find that Jennifer Crumbley and James Crumbley had a legal duty to protect the victims in this case. The victims were the 4 people that got shot and killed. So the victim in a car accident would have, the idea here is that because of the fact that the parents have again, and we're going to I'll pull up the legal duty here, but the idea here is that parents have a legal duty to ensure that their children don't harm others. So as a result, the way they legally theorize this case is that the Crumbley parents had a legal duty to ensure that Ethan did not gain access to a firearm because in other words, okay, let me back that up. That once they realized that he was a mentally deranged individual, which they said should have become apparent 6 to 7 months before, that they had a legal duty to prevent him from getting a firearm because it became clear that he was a mentally unstable individual, and that it was not at all, and that would have meant that it was a potential risk that if a firearm was in his life, that he would take that firearm and do a mass shooting. So as a result, the legal duty is to the victims in the school because they were his victims. In other words, they become the victims of Ethan's became their victims that they had a legal duty to protect. The idea in this case, and this is, again, I think something that's been lost on people, and this is why you see Shannon jumping up and down and why attorneys are jumping up and down saying this is a total misapplication of this law. The legal duty in this case was not to Ethan. It was to the 4 victims that lost their life. And the idea was that James and Jennifer Crumbley, or in this case, we were just dealing with Jennifer, that she had a legal duty to protect those children from her son. And because her son was a minor and was not an adult, that every parent has a requirement of providing ordinary care to protect others from the actions of their children. And in this case, that's why they said that's why in every in whether you go part 1 or part 2, grossly negligent to get to gross negligence in this instance, the gross negligence was committed against the victims, not Ethan Crumbley. And it was and this is why this case ended up in the appeals court in such a novel case, because the victims of Ethan Crumbley became the victims of James and Jennifer by default of him being their son. And they're saying that if they knew he was again, this is why the only way this case gets to guilty is they have to find either way on either side of this. They have to find that James and Jennifer knew they had a potential school shooter in their house, that they were choosing to do nothing about it, and that they then allowed for the firearm to be accessed, knowing that he was a potential school shooter, thereby putting at risk the 4 victims in this case that ended up dead, and that they had a legal duty to those victims. Well, that's the whole issue. See, and let me put this up so everybody can see. I realize I don't know. That is the whole issue. That's why I said it's such a significant fact that juror is standing in front of the courthouse and on Good Morning America or whatever that show, Today's Show, saying I wasn't worried about the diary. She missed the fact that there is a gap in between, that there was not an automatic responsibility. There was not an automatic legal duty to those victims if Jennifer and James Crumbley didn't understand their son was a risk to those victims. So you can't get to guilty unless they knew and believed. And that's why Shannon was so focused on that, but she forgot to get in here and make sure they understood that link. was on both sides. And she kind of just dismissed the first one and said, well, you'd have to believe she had some responsibility to the firearm or accessing the firearm. And she only was worried about, because basically what the state did was is they slid in there, they said, okay, you've got the access to the firearm. And yes, on its own, you go access to the firearm, and then you have to say that she acted in a grossly negligent manner, which is she gave him access to the firearm and knew that. In the defense's mind, 3 days separated where that was at, and it was pretty clear. I mean, if you're following the evidence, I'm not sure why they missed the part that James thought the gun, that based on the text messages between James and Jennifer, the gun was at the house. Okay. The gun was out of the car. James had clearly gotten the gun out of the car, brought it back into the house, and in police statements and everything else. But apparently that wasn't as clear as we thought, right? So the defense wasn't really worried about that. Now with James, his case is a little more complicated because you have to worry about both sides, because the jury could find that, okay, if he told Ethan where the gun was, and that's somehow proven, maybe they have text messages between James and Ethan knows the gun's there. And he says, son, the gun's here, but I got it locked up. And he says, well, I always would keep locks on it or whatever. There's not an illegal obligation to store it in a case in the state of Michigan or anything like that. But the idea would be that if he thought Ethan was a school shooter in the making, and was a risk of shooting up a school, and was a risk of being mentally deranged, and was mentally deranged, and was seeing poltergeist and hearing voices, and he's still letting his son go to the shooting range and teaching him how to shoot and, doing all this stuff, they would say that's grossly negligent. Any victim that comes as a result of an intentional act that Ethan does with that gun, you should have known he was going to do this intentional act because he was nuts. He was crazy. The problem is they didn't have the evidence of that. By all means, these parents were not reacting like, I knew my kid was crazy. I knew he was going to do this. We tried. Oh my God. They were reacting like, holy shit, what the hell did he just do? He's always been a good kid. And by all accounts, the school had no disciplinary record on him. The school officials were treating him just like you would expect a kid that, when they saw what he was drawing, their assumptions was good things, that he's a little bit of a nerdy kid. He's a little bit of a socially awkward kid. He's having some struggles, and boom. So, that was the big issue. And that's now, the issue at hand is that this wasn't made crystal clear. And that, again, the defense attorney just was not, I don't know. I mean, I didn't think she was a bad attorney at all. She made good arguments. She just, I think, was a little out of her element in this case. I think she was a little bit caught up in the negative criticisms. And instead of getting focused and going right in and putting her board up and saying, on this one, you got to find this. And if I'm her, I'm putting both sides, and I'm putting gross negligence in the middle, and I'm saying everything runs through foreseeability. You can't get here on either one. Yes, it is two separate theories, but both require them to believe he's a school shooter. You don't get away from that. It's not just as simple as he has access to the gun, and that needed to really be crystal clear to this jury, and she could have argued that, and she could have spent as much time as she needed on that to make it crystal clear and watch as it comes through. Yes, because he pulled it from the hidey hole, opened it on the bed, found it out. Yes, that was obvious. I know, apparently, thank you. And that's why I thought it was completely there. And yes, the counsel worried about suicide, not homicide, which indicates right away that, again, from the counselor's perspective, looking at this, from looking at Ethan and everything he knew about him and the whole situation, nobody's thinking school shooting at that moment. And neither would the parents. There was no reason to think that. I don't know. You're right. We never did hear that. I don't know why we never heard that. That's actually, something. Wow. Mads, that's a great idea. That got lost on me. Yesterday, I was so shocked by the verdict, but you're doggone right. I mean, unless that happened out of the earshot of the cameras, one of those times that the cameras were up in the sky or whatever, and we didn't hear it, or maybe it was done in writing, But she never made it at the end of the state's case, which was kind of odd because that's the time you can put out the theory and you want to do that. And then at the end, she sat there stunned and never made a directed verdict. I mean, she still has time to do it. I think you have like 10 days to do it. No, I don't think. I mean, again, I don't know, man. I mean, there's a lot here that I guess the appellate attorneys have to look into. And like I said, I think Shannon was a little overwhelmed. I don't think it was. I definitely do not believe it was her best performance or her best case. I think she struggled in this case. And I think it was readily apparent that she was struggling. Why that was, I don't know. Let me see here. Do we have duty of care? Did I put that in there? Defendant statements. Okay. So here's the alternative theories, and this was what was read to them in response to the question. Those theories are two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you agree on which. See, this was the issue right here. This is why and I know Shannon was asking for something else to be read in, but this is what the state asked and the judge let. And if you think about the confusion that they were having at that moment and the way they're reading it and the fact that they're not seeing, again, I think Shannon wanted to have the gross negligence read in because she wanted to make it clear that was needed. And the state said, and again, Mr. Keys set up and said, well, what it is, see, it sounds weird, but it's not weird. What they're saying is this. There was the duty of there's two. So it is not necessary that you all agree on the theory that has been proven, as long as you all agree that the prosecutor has proven those theories at least beyond a reasonable doubt. So let's go back and look at and bring this in again. I understand why this would be very confusing, and it is on the forefront when you first take a look at it, take a glance at it. Here are the two theories, right? So, defendant caused death. In doing that act, caused death, defendant acted in gross negligence. Normally, that would be something like he pulls the gun out, he mishandles the gun, he points the gun, he glocks the gun, they're driving in a car, and he's texting on the phone. That would be a normally lawful act that would not be considered to be against the law. He's just doing something, but it's done in a grossly negligent manner. In this particular case, what they're holding is that this would be failing to secure the firearm. So they got that part right. What they got wrong is that it has to be that they acted in a grossly negligent manner. What they misunderstood was what rises to grossly negligent manner. The second part is the defendant had a legal duty to the victim. And the legal duty part, the theory of that case was saying, okay, let's say in this case you believe, which is the correct thing here, she didn't have anything to do with the firearm if you believe that the dad took the firearm out of the car. At that point, she had nothing to do with storing the firearm, and they knew that was a pretty weak link. However, this is why there was so much focus, because when you get into this part right here, the gross negligence and failing to perform a legal duty, this is solely about the fact that at the school, he drew on that math worksheet, and that the state's theory was that math worksheet should have made them realize by looking at it and understanding that they had guns in their household, and that 7 months before he was talking about, people were in the house, clothes were flying off my shelf, that they should have known that he was mentally disturbed, and that as a result, seeing a worksheet with a gun on it, a gun that they had just bought, seeing it saying, make them stop, make the voices stop or whatever, that the parent should have looked at that and said, oh my God, he wants to shoot up the school. Not that he wants to kill himself, Not that, but that would have allowed them to see, oh my God, he's about to shoot up the school. He's a disturbed kid. We've been dealing with these disturbances for 7 months, which really there was no indication that was true. But in their mind, he's lost his grandparents. He's lost his friends. We know school shootings are something that's prevalent. We have to assume here that he's talking about shooting up the school, and that Jennifer Crumbley should have taken him out of that school and either taken him home or taken him to work, but that she had a duty to take him out of that school at that moment, and she neglected that duty, knowing that a school shooting was likely and probable outcome. And she just said, you know what? I'll roll the dice. I don't have time for this. Screw it. If a school shooting happens, it happens. And she left the school. That's why Shannon was jumping up and down saying, this is ridiculous that we would believe that she thought a school shooting could happen at that moment. So the jury dismissed this. Or at least that juror said they did. She said she didn't care about this. She didn't think that Ethan Crumbley's mindset had any issue in this case. That is wrong, number one. That's disturbing, number one. But that's what she said. Because what she found was somebody went back there and said, we've interpreted this. Gross negligence in the performance of a lawful act. She was handling a firearm. She stored a firearm in her vehicle. It was negligent because it allowed him to get access to it. And they believed, and this is the fault in what they believed, first of all, that it was clear that that really wasn't what happened. But let's just take for a minute that it did, right? Let's just take for a minute that we say, okay, fine. You think that you believe Minash and you believe, or Malash, whatever you say his name, you believe all that, right? And you believe that she left the gun in the car and that's how he got access to it. Okay. That alone is not enough, but that's what they thought was enough. Because in their eyes, that's negligent. That's gross negligence. You left a kid with a firearm and then the deaths happened? Well, she should have known that somebody could have died. No, because the theory in this case, because the reason why that is not a legally permissible theory in this case is because it wasn't a result of an accident. There was an intentional act, meaning he took the gun and committed an intentional act, which she could not have foresaw. Normally, that's why you would not have a charge in this, because it's like, who would have thought he would have grabbed the gun out of the car and then gone down and shot up a school? So there, as a result, the negligent act of leaving the car in the vehicle is not enough to rise to criminal negligence. As a result, no charges would have ever been brought. In this case, this is the carve out where they said, no. And this is why it ended up in the Court of Appeals. We see this case because of the fact that there were the text messages from March and April, because of the fact that he had written in that journal, and the journal was allowed to be considered by the appeals court. And he had said, I'm shooting this school up because my parents ignored my mental health. Because of the ignorance of these parents, this has created a carve out. This has created a situation that is outside of the norm. And as a result, the intentional act actually becomes part of the parent's responsibility because they had an opportunity to prevent the intentional act from occurring because they knew he was mentally unhinged, and they still kept firearms in their house anyways. And that's why firearm owners and stuff are so at odds. Because they're like, hey, you stored the firearm. And that's why the whole idea of whether it was legal to store firearms doesn't matter. The state was saying that, yes, we acknowledge it was legal to store firearms. But what they're saying is that in the legal duty of care that was required, because essentially what they're saying is that the legality of storing the firearm, whether it was stored legally or not, it could have been stored legally with a lock, with everything. But what they're saying is that the Crumbleys should never have kept the firearm in their house to begin with, period. Because they should have known that Ethan Crumbley was a mentally unstable and deranged individual, and they should have gotten rid of all their firearms. That's the crux of the argument. They did not quite go that far, but they laid it out there. But that is the crux of the argument that they're making. That's how they get around the idea that it doesn't matter about legal storage. It really didn't matter where the firearm was at. And that's what, again, that's why Shannon should have been standing up. I don't know why she made the argument in the closing arguments where she said, the whole thing about sending minors sending pictures to each other, naked pictures to each other. I mean, no basis at all in this case. She was saying, well, should that be illegal? What question are you asking? No. The whole issue in this case is did the parents believe, do you really believe these parents actually thought their son was the next school shooter? And do you believe that if they really believed that they would have done nothing? That is the crux of this case. In either of these theories, yes, they could have two theories, but both of those theories require you to then travel through the foreseeability test. And it has to have been foreseeable, which requires them to have believed that their son was exhibiting mental health issues to the level and degree that would have made them believe that a school shooting was foreseeable, or that he was going to go out and do a mass shooting of some sort, and that he was going to take the weapon and turn it on others. And that is the test that they did. That is the, if you read the, again, I haven't put that case up, but perhaps I will do that, in a future discussion. But if you read the brief, that's what they discuss, and they get into it. If it can happen to Jennifer, then it can happen to you. Maybe not with guns, but with knives or nude pictures. Right. No, I understand that. But I think the problem is she had a very, very strong argument. Okay. And she was worried about arguing against the whole idea that Jennifer Crumbley was a bad parent and all this stuff. But the strength of the argument in this case was not about any of that garbage, right? She was making an emotional argument. The whole idea here was the state didn't have the evidence. When she makes an argument like that, she's making an emotional argument. And perhaps in a sex offense case, it works. But in this case, this was a case where you really needed to hone in on what does the law require and make them understand. And one of the, if you want to go watch, Bruce Rivers does a great job of talking about this because he's a great lawyer. I think if he would have been defending the case, it would have been a completely different outcome, because he hones that home. Talking to my dad when I was talking with him, he honed it in and helped me understand it. When you talk to a lawyer that really understands how these things work and how these things apply, they can make it really understandable. And they say it's an issue of the law. It's not like there is negligence here, but it's a level of negligence. It's a degree of negligence. Well, yes and no, but you don't, here's the issue, Matt. Yes, in some cases you would, right? But you don't, what she was doing was fighting emotion with emotion. She was complaining about remember, one of her big things is the state attorney's office decided to try to inflame your emotions by putting on all this stuff. We stipulated to all this stuff. So you make that issue and then you turn around and try to implore to their emotions. So what you're doing is you're saying, well, okay, it's so offensive, I'm going to do the same thing. No, because it isn't emotional. And in fact, one of the jobs of the defense attorney is to remove emotion, because the presumption of innocence requires you don't put emotion in there. If you understand, and again, this was the problem. This is the real issue. And I think someone said this in the comments. The issue we had here is the jury was approaching this from after the fact. They were approaching this from the point of the shooting. They were not approaching, they were making the assumption, and they were almost doing it from an assumption of guilt. The whole point is when a defense attorney stands up, and my dad, I've talked with him, and he was very successful at what he did. And he, at a very young age, when we were talking about things in trials, he would always tell me, when you stand up in the opening statement, the first thing you really don't want to get into, the defense doesn't really want to get into talking about what they're going to prove, because you don't want the jury thinking about the things you're going to prove, because you want them to understand you don't have to prove anything. You want them to understand that your client is presumed innocent, and that the power of that presumption, that is the point of where we're looking at this case, and that we ask the questions. Every question asked, every piece of evidence comes in. You start from a point of innocence and you go from there. You don't assume guilt. You don't do what the press tells you to do. You don't do what the movies tell you to do. You don't do what the prosecutor's going to want you to do. And that is assume guilt. You don't assume because the person's sitting in that seat that they're guilty. You can't do that. You have to assume innocence. And it's the hardest thing for people to do, is to set aside that. Set aside the fact that police have charged this person and investigated this person, and there's several state attorneys sitting at that table, and there's a police officer sitting at that table, and they're sitting in that table, charged. And it's hard for people to think to themselves, well, could that person really be innocent? They have to be guilty of something, right? They're already sitting here. No, the law says you don't do that. And that's what the first hurdle the defense attorney has to do, is get that up there. And then they have to let them know, listen, when we start looking at this case, our job here is to start asking questions. And the job of the prosecutor here is to prove the elements of their case. If there's even, and now Shannon did a very good job of this in her closing, pointing out the fact that if there's even one doubt, and I think when you watch that Juror 4 person, she's the epitome of reasonable doubt. When she asks and she's wavering, she's vacillating, she doesn't know, she's not even certain how to answer the question of guilt. If there's any doubt whatsoever, one doubt at all, then you find them not guilty, because then you presume innocence. You presume innocence. You have a conflict of evidence, presumption, that conflict is handled by presuming innocence. You have an inconclusive result, we presume innocence. It's a unique situation. It's against human nature. It's against almost everything we have in our minds and the way we process things, which is why you need a good defense attorney sitting at the table helping people to understand that. That's why Tyrone Tucker needs to have a good defense attorney, even though he feels he doesn't, and he did a heck of a job for a pro se defendant. But you need a defense attorney who can talk to the jury to make them understand this, and they've got to be likable too. They've got to be willing to come in, and the jury's got to trust in the process. And you've got to, again, most cases are won in jury selection, which is why I felt Shannon had saw something in this jury, and she was acting to the jury. She was part of picking the jury. I know she's an experienced attorney, and I thought, okay, this has to be part of her strategy of how she's acting and what she's doing here. And then when she's closing with the whole emotional close with, this could happen to you, and da 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 da. She had to have seen something that she felt like, and she's using herself. I mean, she had to feel like she had really bonded with that juror. I was assuming she saw signs, that, because, if you're gonna say I could be there, then you have to expect that the jury thinks enough of you that they don't think that you would do something like that, right? Otherwise, they might say, well, yeah, you've just been lucky, lady, that you're not sitting there. Well, I agree. I think the forewoman. To me, I don't think that forewoman necessarily fully would have been able to appreciate. She seemed young. Let's put it that way. She seemed very young. I don't think she would have really been able to have put herself maybe she has kids. I don't know, but she seemed awful young to me. I don't think she has teenage kids. I don't think she would have been able to have seen through that. And I think that she didn't seem very defense friendly. Although I felt like it seemed like when she went back there, when she spoke to Good Morning America, and she was talking about the impression that was made by the testimony of Jennifer Crumbley, I felt like she was almost saying to a degree that that had made a positive impression. But I think she was swayed. I think for her, when she got back there, whoever it was that brought this into the jury and said, hey, there's two facts. Again, remember, what we can ascertain now is that somebody back there had it right. They were saying, we have to decide whether or not she had whether or not it was foreseeable, and whether or not she thought he was a school shooter. Somebody back there was making the argument, no, that's not correct. Remember, the judge said there's two different theories. One of the theories is about if they don't secure their firearm and then he goes out and kills somebody, that's negligence too. And then there's the theory. Then they were saying there's the theory about, whether it was foreseeable, but either one is okay. And nobody clearly back there in that room understood how to read these instructions and understood. And this is why I say, if you're assessing the job that was done here, you're going to say this right here, grossly negligent manner. Okay. It was grossly negligent to human life, neglected her duty, blah, 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 all this stuff, the duty, but grossly negligent manner still connects with foreseeability. You can't get to guilty without them foreseeing that he was a school shooter or that a school shooting was likely or a mass shooting was likely. We wouldn't say school shooting, that he was going to be willing to go out and take a human life intentionally, and that they believed was mentally deranged. Otherwise, the act of leaving the gun in the car doesn't rise to criminal negligence. It's carelessness. It's still negligent, but there are 3 levels of negligence. And in fact, hold on a second here. All right, so I got I don't believe they showed this. I'm going to show this will help, I think, when looking at this. Let's see here. Get a homicide. And then we've got, all right, so let me share this now. Okay, so this is hopefully it's coming through. But this is the degrees of negligence. So basically, there's ordinary negligence and there's gross negligence. And this was essentially the 2 theories of the case. One being duty to act, one being gross negligence as an element of manslaughter. But essentially, what we would have termed normally this to be would be slight negligence, meaning doing something that's not usually dangerous, something that only an extremely careful person would have thought could cause injury. In this case, if you find that the defendant was only slightly negligent, you must find him not guilty. And that would be leaving the gun in the car. That's slightly negligent, but there's no causal link that says at that point, and again, under the theory of this case, because of the intentional act, it breaks any linkage to what he does. So as a result, it's not criminally negligent. Now, it rises to gross negligence if they believe that there's a likelihood that he's going to do a school shooting or a mass shooting, and they leave that around him, and they take no steps to get rid of the firearms in the house. And then he takes it and does that because now the intentional act, they're saying, because of their legal duty of care. And I don't think I have it in this section here. Give me another moment. All right, so here is legal duty of care. It's this one. Nope. It's this one. Okay. So because this is the crux of it right here, that in Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others, to prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. So the theory is that if they knew he was mentally unhinged, they knew he was likely to harm others, they knew he was having mental problems, and then they allow a firearm in the house and they allow firearms to still be in the house, that allows them to get to the gross negligence factor that allows them to still be connected to this crime, even though it was an intentional act that normally, if it was an adult child, say, right, and I just knew, hey, my son's having problems, and I knew that he had firearms in his house, I mean, there's nothing I can do. Or I let him come into my house and he steals my, excuse me. Apologize. That was my guard dog. But, that ends up being the issue here, that they had a legal duty to do something about. So, like I said, in this case, apologize, everybody. Anyways, we're going to wrap this up. Like I said, my dog, he barks at everything that goes along the out front there. So he's decided to come out and I guess go on patrol. But anyways, the point of everything is that this juror brought to light, some interesting facts. And I think it's very clear that the defense attorney made a big mistake here by not explaining the way the foreseeability test is what it's really called, that has to be applied to both sides of this argument. It's got to be applied to the idea that they had a right to, that if they were going to have guns in the house, or if a gun was going to be with it. And again, this is something that the attorney should have made clear is that the issue at hand wasn't storage of the gun, that in this case, it was the idea that the only issue at hand was, even if they believed at all that Ethan Crumbley was a threat or to do a mass shooting, then they had an obligation to get rid of the guns. Bottom line. Like that was was the theory of this case. So the mere storage in the car, and again, the reason why they would make that argument to the jury is because they would say her storing it in the car, her leaving it in the car, him hiding it in his underwear or wherever the hell he was hiding it, him keeping it in a case or not keeping it in a case, isn't relevant. Okay. Bottom line is Ethan Crumbley lived in the house. Ethan Crumbley was aware the firearm was in the house. That is a fact. We're not disputing that. The only fact in this case that makes a difference, the only thing that makes that negligent is, did they believe he was a threat? Did they believe he was going to do a school shooting? And if they didn't believe that, if they don't believe the evidence said that, it's not guilty. It doesn't pass the foreseeability test. On the other hand, the reason why they brought in the second version is they say, okay, you dismiss that. But again, to dismiss the fact that the mere presence, again, and to have really made less confusion to the jury is by attaching the foreseeability test into both sides. It basically says that we know the gun's already in the house. So the only issue in this case is foreseeability, because by nature of that gun being in the house and them having stored that gun in the house, it's not normally a crime to do that. Obviously, Michigan, you're allowed to possess guns. However, the legal duty of care that attaches to a parent, knowing that they have a child who is exhibiting signs that he would be a mass shooter or that he would be wanting to do harm to others. Okay. And if they knew that and they still kept their guns in the house, they're attached to this. So then this juror who got swayed by whoever this was that brought this up, the jury, this would have never been allowed to run rampant, because they would have been like, that doesn't matter. Her storing the car, her allowing access to the gun, like this juror really was telling when she said she didn't do enough to separate access to the gun. This wasn't an access issue. We know he had access to the gun. This wasn't an issue of her obligation to say he can't access a gun, because it wasn't an accidental situation. Because what we have here is an intentional act that he was intentionally sought after and intentionally went forward with going after the gun. In fact, the prosecution, you can almost say, obscured this a little bit because they wanted them to think of it in that term. Because the actual issue at hand was the prosecution was saying these people should not have been gun owners these people should not have been gun owners with a son doing the things he was doing. But the reality was, what are you talking about? I mean, when you look at the messages, I don't think I would not have concluded based on the messages I saw in this case and read in this case and the things I heard in this case. I would not be thinking my kid was the next mass shooter. And that would not be what I was thinking. And I firmly believe, based on the way, in fact, and this was again a missed opportunity by the defense attorney. She should have been arguing that all the things the state were saying was evidence of guilt was actually evidence of the fact that these people were shocked by it. And the fact that they were shocked by it means they couldn't have foresaw this because they were shocked. They understood the consequences. They said their life was over. They're realizing they're going to get charged. They're realizing they're fucked. They're realizing they're in trouble. They're realizing, holy cow, our son did this and we're going to get, and people are coming after us. They clearly didn't want this outcome. And in order for the state to have proven beyond a reasonable doubt that this was a foreseeable outcome, you would have to believe that they knew it, ignored it, and didn't care about it. And that rises to criminal gross negligence. And the way they acted afterwards actually does not act at all like the consciousness of guilt, like they tried to say. Again, the consciousness of guilt that the state was putting in here was Jennifer Crumbley knew she left access to the gun. She knew she had done negligent things, but that's not the definition of negligence as the law holds for her to be found guilty in this case. And the jury obviously did exactly what they wanted. They got inflamed. They went back. They got creative. They figured out a way to convict. Once the few people had their theory of conviction, they went, activated, and turned it on everybody else. The confusing instructions, the multiple theories, all of that got used to absolutely, and the foreseeability got viewed as if that was part of one side and it wasn't part of the other side, when it was actually part of both sides. So in order to eliminate the one side, and this is what a good defense attorney would have said, you can't even move up like foreseeability. So start over here. Access the weapon. We concede, we stipulate. It's in the house. Next issue, foreseeability. Deal with it over here. And if a good attorney is going to say, take it one at a time. There's two theories, but let's take it one at a time because there is one piece that is inextricably linked in both sides, and that is foreseeability. Because the legal duty to act means they had to have thought their son was mentally deranged to the point that he would harm others. That's on the other side. That's what they had to see in that worksheet. That's what they had to see in that moment. But if you come over here and you say they would have never thought this, and then you come over here and you say, well, the school is calling them in about potential self-harm, and you say still wasn't foreseeable. Would that sheet have changed it? Absolutely not. School officials are saying it's okay to take them home? Absolutely not. Foreseeability is gone. There's no evidence that it was foreseeable. There's no evidence that they would have thought that this was foreseeable. Yeah, she had an affair. Should have never come in. Yeah, she was on ski patrol. Yeah, she was doing all sorts of other stuff. So what? But that was the game that the prosecution wanted. So now we've handed it to them. And what we've handed them to is, like I said, it's just going to get crazier. Because this theory that they believe they have been emboldened now to take forth, this theory of you're now responsible to foresee all evil acts of your child. It's coming, man. And believe you me, they're not going to stop until they get stopped. But when you have juries like this, who again operate under the idea that she's here, we assume the worst. We get back there and again, this jury operated from the wrong perspective. Because again, if you take this from the idea, remember this now, and this is what she should have done. The presumption of innocence means we presumed that Jennifer Crumbley didn't believe the killing was foreseeable. She got that presumption. And the state has to overcome that to all doubt. This case was as if they had to prove that she thought it was. That's not true. The idea was this jury starts from the point we presume that the Crumbleys did not believe this was a foreseeable outcome. The state had to prove beyond all doubt that it was a foreseeable outcome. And when you start from there, there's no way this jury gets there. But again, this whole case, this whole production was a mess. And when you look at it, no way, maybe self-absorbed, but if Jennifer Crumbley could even fathom such a thing, she would have done different. I have no doubt. Absolutely, she would have done. And they hinged on that. That was a poor choice of words. I mean, and it did look. Okay, she wasn't well prepared to get on the witness stand because she opened the door. I can't remember what it was now, but she opened the door in the way she answered a question at the end of the first day, and they ended up having extended arguing, and it ended up being a nothing burger. Oh, I know what it was. It ended up being to her text message to her lawyer. I mean, that was ridiculous. Again, like I said, I'm trying to give Shannon Smith some credit here because I don't think she's a terrible lawyer. I just think this case, for whatever reason, she wasn't very prepared for it. I know she had some health issues. I remember I went back and watched about a month ago. She didn't even appear in court for the final pretrial, one of the final pretrial hearings that Mr. Crumbley and her were appearing for. I can't remember what it was, but it appears, in my opinion, that this was not a case that she was preparing for 2 years on. That this was a case that she had begun her preparations for not soon enough. Let's put it that way. And that she wasn't prepared for this case, and didn't approach this case to me in the way it needed to be approached in order to get a not guilty verdict, because it was just all over the place. And then she puts her on the witness stand, and that was a disaster, and things were said that should have never been said, but she should have been down at that jail preparing her for this, and they should have been prepping, and it should have been, for her to have said the things, like the one thing that gets used against her comes out on direct. Was there anything you would have done differently in this case? No, not at all. Why would you even ask that question? I mean, there's a different way you could have done it. And it said, looking back, do I think I could have done anything to change the outcome? No. But I think there's a few things. Obviously, as a parent, I think I wish I would have asked a few more questions. I think I would have, in hindsight, there's lots I would have liked to have done. Do I look back and say, do I think I could have changed this outcome? I now know from having reflected on it and talked with counselors and talked with others. That's a very tough question, because there's so much I wish I could have done so much more. I don't know what I could have done. I look back at the circumstances, and there's such a different way she could have answered that. But for her to answer affirmatively and give them that headline, and then we find out, that made a difference to the jury. With the way that with some of the jurors, absolutely. I mean, and this adds up to, which adds to how messed up this. Yep. And it sounds. Let's see here. What's the next? And it sounds like the jury didn't think it was foreseeable. What a travesty! I know. And attorney-client privileges. That's what it was. Yes, it was attorney-client privilege. She opened it up. I mean, that was just ridiculous. And again, like I said, I've looked into. I'm only listen. If this was some inexperienced attorney that didn't have a history of being a competent person, I would have looked at the performance in this case and said, this person's just wow. But there was something more going on here, I think. Do you think the ineffective assistance of counsel is an appeal angle? It's not a direct appeal issue. Okay, so understand how that works. That does not come in on direct appeal. That comes in as a second set. That's when they can do that. I believe it would be under a habeas. They can come in and do that. But the direct appeal will be just simply an appeal on the record, and then there'll be a second. That's a second round of appeals that can come in later on. And I agree. Why promise to put her on the stand in an opening statement? I think, like I said, again, opening statements, defense attorneys, they come up and they I see it all the time in cases. They promise too much. I mean, defense attorneys want to do all this because I think sometimes the defense attorneys themselves have watched like TV shows and and they see this stuff and they're cut from the same cloth. They're human beings, and it's like, why are you promising to do all this? You don't need to do all this. You have the presumption of innocence. What you need to do when you go into this courtroom is you need to say yes. This is not a fact-finding mission. The fact-finding investigation was the police's job. And I mean, this should be just explained at the beginning. That was the police who did that. The review, now the prosecution did a review of the police's work. And the prosecution said these crimes were committed and we can prove it beyond a reasonable doubt. Now, your job, now the good news is it doesn't stop there because we have a trial. And that's where you come in, jury, and you get to review this case. And they have to put this case up. And not only do they put it for you to review, but I get to ask questions and assist my client in asking questions. And if I feel the need, if my client feels the need, we can put up evidence too. But the goal here is we're not here to find fact. We're not here to prove anything. I don't have any obligation to prove anything. The state is here to show they have a case that is, and at the end of that case, that they can prove beyond a reasonable doubt all the elements. But when you're assessing this case, you don't assess and assume that because this case was brought that the client's guilty. You assess it from the presumption of innocence, and it should never be stated we're going to put the defendant on the witness stand, because in this case, she didn't need to go on a witness stand. They had her text messages. They had everything. They didn't need a proclamation from her to get on the stand and say, I'm a great parent. I mean, no. This was a legal case about what she knew and what she didn't know. And there was nothing she could testify to, in my opinion, that helped the case one way or another. I mean, she'd done enough talk and enough things. It was really a non-issue. And then by bringing her on the stand, it allowed them to question her about all these salacious things. And I think Shannon Smith's idea was we want to turn the jury on the prosecution team, and we're going to evoke sympathy, and they're going to look like they're attacking this mother who's also a victim too. Like when they asked a strange question, do you think you're a victim, or whatever the hell it was that she asked, which I thought, well, why the hell would you ask that question? And she said, we've lost a lot. I mean, yes, Jennifer Crumbley is technically a victim here, if in the sense that her son did this, and she's lost her son. He's in prison for the rest of his life. She's going to be potentially held monetarily accountable in some ways. She's going to probably have to pay some money out. She's got to go through the guilt of knowing that her progeny, her son, her person, the human she created, went out and took life from others. So yeah, she's a victim in one sense, but why the hell would you ask that question? I mean, what she should have been asking was, what do you have an opportunity here. One last thing. What would you say to the victims? And what she should have been saying is I just want to say to you, I'm sorry. I'm sorry that my son did this. And believe you me, I want to speak to you and let you know if there was anything I could have done to stop this, I would have done everything I could have. She had an opportunity to have a powerful moment. And she didn't do that. And if she would have done that, maybe the state would have jumped up and objected. If she would have done that, man, it would have been case over. Whoops. So let's see here. Imagine if Mark Iglash had that case. He would have got a not guilty. I know he couldn't be in the case, but he would destroy the prosecution. Who is Mark Iglash? I don't know who that guy is. I'm not certain who he is. But potentially, if he's a good attorney, and in Shannon's defense, you can't really control what the defendant will sentence. Well, okay, you can, because just like when OJ was being prepared for his trial, his attorneys put him through mock cross examinations. Okay. And you don't know what they say, but you have an idea how they're going to react, and you make sure that they're not going to, you control the questions that are asked. I don't know why she asked some of the questions that she did. And you never ask questions you don't understand what the answer is going to be. And she doesn't tell them what the answer is, but she can ask all those questions and say, okay, we're going to sit down and we're going to go over your testimony. Here's this question, here's this question, here's this question. And you decide if you like the answers or not, because since you're deciding whether or not to put it in front of the jury. But I don't think she actually, like she said, I didn't know what she was doing. I wasn't expecting her to say that. Well, if you've prepped your client, you should have known what she was going to say because you should have already asked the questions. Let's see here. Putting her on the stand did allow them to show. It did, but they could have done that potentially through other ways. I think. But even then, listen. The issue wasn't absentee parentism, in my opinion. The issue was whether or not she. Now listen. I will say this. I felt like listening to her made it sound like she was just like this was just a regular family. I mean, you heard the customs, traditions. I felt like she did a pretty good job, except for the final summarization of questions, the final few questions when she failed to hit it out of the park on asking again, what would you have done anything differently? No. I mean, that was horrible. She should have had a different answer for that. And then it shouldn't have been, do you think you're a victim? It should have said, what do you have to say to the victims' families of your son? What would you like to say to them? And she could have just absolutely you have an opportunity right here. What would you like to say to them? You have ability. You've waited for 2 years to say it. What would you like to say? And she could have very openly said, I am so sorry that this happened. And if I would have had any inclination or any knowledge that my son was going to do something like this, I would have done everything in my power to stop him. I am so sorry this happened. And I had no idea. That this was even a possibility. She would have had every right to say that. But the cross was weak. I was expecting, I thought when he was saying, all right, we're getting things ready to go. We're going to come, for the cross. And I'm like, okay, they were, I was expecting this thing to be like just brutal, and it really wasn't. But I think that also speaks to the fact that there really wasn't much to cross on because they didn't have anything. They had nothing. Well, that's why. Well, I agree with you. I agree with you. That's why I would say the correct answer to that is not an answer. It's a middle of the road answer. You don't say there's nothing. You just say that that's a difficult question to ask, or it's a difficult question to answer. I mean, if I was sitting in that situation, I'd be saying, I look back, I cared about myself. I mean, it was an opportunity to really what it is. It's a door opening for her to talk about. I feel like I spent a lot of time with my son. I knew my son very well, and I look back at our relationship, and it is hard for me to pinpoint any particular thing that I could have done because I was so surprised. I was so shocked. I was so devastated when he did this because I could never even imagine him doing this. It was so out of character. But, were there things I missed? Of course. I wish I would have gone in his room and looked for the journal. I mean, there's 100,000 things that go through my mind every night while I've been sitting here in my jail cell waiting for this day. That I just wish I could have done differently because at the end of the day, the biggest tragedy in this room, the parent sitting over there that lost a child. And although I lost my son from a physical standpoint, he's still alive, but I can't imagine being them over there. And it's such a devastating tragedy. And I wish every day that I could have done something. I don't know what that was because I feel like it was so out of left field. I never expected it from him. Saying something like that, right, would have hit it. Saying no, just coldly saying no, made her look like the cold ass bitch that the prosecutor wanted her to look like. And yes, I agree. She didn't have the warmest affect. She probably, had some culpability in the idea that this young man was depressed. But I don't think she had any idea that her son was a school shooter. I do not believe that. The correct answer is if I could turn back time and yep, but alas, I cannot. Exactly right. That is exactly right. You're talking about Mark Garagos then. Is that who you're talking about? Mark Garagos was Scott Peterson's attorney in the Parkland shooting case. Mark Eglash. Never mind. I'm sorry. Scott Peterson. Oh, okay. Yes, that gentleman. Okay. So he was in a different state then because that was, wasn't that down in Florida? Or was that, that was Florida, right? Well, I mean, listen, that's why I said, I mean, she hired Shannon right away. Like I said, Shannon is listen, the hiring of Shannon. I mean, Shannon was hired. Remember, Shannon represented Larry Nassar. Now, Larry Nassar took a plea, but I'm saying she was in high profile cases. If you go to her website, if you look her up, she's well touted. She's voted peer reviewed as a great lawyer. The selection of her as an attorney, the only pause that would have made me pause when I'm putting her in this type of a case is her specialty was sexual assault cases, sexual abuse cases. And that is a different deal than what you're dealing with here. It's still criminal law, but it's different. It's like I said, it's like getting a tax attorney to represent you when you're Mike Tyson on sexual assault charges. It's a different style of defense. It's a different style of law, and it's not the same. And there's different strategies. There's different ways you would argue the case. There's different approaches. In this approach, they needed to have someone there that could really hammer home to the jury how to deliberate this case and what was really important. And really, like I said, I don't know. I don't know what the lead up here was. I don't feel like she wasn't capable of doing that. I just feel like she was like triggered by the prosecuting attorney, and she was triggered by the media, and she was triggered by the criticism, and she seemed to be unprepared. She seemed to not really have a strong command of the case. That's what I thought. Knowing what I knew then, no. Knowing what I know now, that's so I can think about trying to figure out. Easy answer. Yeah, there you go. Yep. Oh. The judge really hurt the defense case, letting in irrelevant things. Yes, well, look, absolutely, and that's why, as I said yesterday, this is an appellate lawyer's dream in terms of finding issues is going to be very, very easy. Now, whether or not the appellate court is willing to step up and reverse the case, given the fact that 4 students lost their life and the controversial nature of the case, it's a whole nother story. But there's a lot of stuff that is absolutely ripe. I mean, ripe as a peach for appealing here. And, there was that, and there are things that materially would change the case. One of them being the admittance of this journal. And the biggest thing is that juror sitting up there saying, yeah, there were jurors in that room that were swayed by that journal. Boom, there it is. And then on top of that, obviously you've got the way they came to allow the case before the jury. In other words, the theory of the fact that, we haven't, one of the issues at hand here, well, of course, the jury didn't even really consider the foreseeability thing, but one of the issues at hand when it comes to the foreseeability is what was the standard that the Crumbley should have assessed to determine their son was at a level of mental instability that they should have removed their gun from the house. And see, what really needs to go into effect, if any state wants to hold this, is they need to have a law on the books or add it to the manslaughter law that says if these things are being exhibited by your child, then you're no longer allowed to have a gun in your house. That's what they have to do. But that's essentially what the state was arguing in this case. They were saying there's a standard here, and the problem here, and this is where you get into a due process issue, because the due process clause holds that essentially to melt it down, there's a void for vagueness clause in the a test anytime a law comes into effect. And essentially, to put it clear, is if you put 10 people in the room and you had them read this law and you had them read the way the law was applied by the appeals court, all 10 people should be able to understand exactly how that law gets violated by the parent. In this case, that's clearly not the case. So when you put 12 people in the room, and they can't understand how this works, there's a problem. And they didn't even understand how foreseeability was supposed to apply here. They couldn't even understand how to test, how to appropriately. They couldn't even instruct the jury properly. So, like I said, there is so much here that it's an appellate lawyer's dream, because these instructions ended up not getting it done. And the interview with that juror, so glad she stepped out and went on the Today Show, because it was clear that they didn't know what the hell they were doing back there. And the way the judge instructed the jury, they didn't instruct them properly. And they weren't able to instruct them in a way that made them understand exactly how to apply the law in this case. And that's because the secret of this is the law itself is inadequate in the way it explained the way the state was trying to charge this case. Again, before anybody says, well, the appeals court already saw it, the appeals court did not take that issue up. In fact, the appeals court was very specific when they took up the issue of foreseeability. They were looking at it only in terms of whether or not it separated the link between an intentional act and whether or not these parents could still be charged with gross negligence. And that being, can you connect? Did Ethan Crumbley eliminate the ability for his parents to be charged by intentionally taking that gun and doing something intentional? And in this case, I believe they created a due process issue in the fact that they said, well, we're going to find they can. And the way they're going to do it is it's a special way you have to see the law. But what they didn't include was number one, how do you explain that to a jury? Number two, how was anyone supposed to be aware? Because there is a right to notify. There's a right, in order for a law to be applicable and enforced, you have to show that the individual you're charging with violating the law had to have been aware that this law was in existence and that this standard existed in the first place. And since they created it after the fact, and it was an interpretation of it, and since reading that statute, not even lawyers can agree on how the state applied it here, we have a problem. And it's a due process problem, and I think that there will be a good appellate attorney that's going to take it up. Let's see what's going on here. So, do appellate Michigan? I am not sure on that. Let's see here. Let's go back here. Knowing what you know. Okay, the judge really heard. Yes, they did. If it's a light sentence. Well, I don't think it's going to be a light sentence. Although, see, what I didn't understand, one of the news commentators, what I haven't clearly heard in this case, the sentence is 15 years. She's going to get 15 years. Okay, let's be clear on that. They're not going less than 15 years in this case. The only question in my mind is whether they can stack them. Now, normally, let's say you had a robbery and a murder, and you had all a part of the same act, deriving from the same act. Normally, you would have a case to be made for that the sentences could be served concurrently, because it was all part of the same act, even though there's separate charges deriving from the same act. So you can make the defense attorneys allowed to argue for concurrent sentences. Now, if the acts are viewed as different independent acts, in other words, he shoots one, he walks down the hall, shoots another. It's part of the same mass shooting, but each one is its own separate deal. So the idea would then be that for at least Ethan Crumbley, he gets stacked sentences. He gets 5 lives. He gets 5. Now, when it comes to the parents, and this will be another novel approach that can come up on appeal. Do you view each one as an independent act, or do you view it as just one act? In other words, he goes to the school, he's got the gun, he's shooting up the school, and do they view that as just it was a result of one negligent act in their eyes, which was the ignoring of the mental health problems, which then leads to a mass shooting, which means it's all viewed as one act. So when you're sentencing, you're not looking at it as it was an intentional act to kill this person, intentional act to kill this person. In other words, intent doesn't spread individually to each person. It's all viewed as one result. And if it is one result, then she'll probably only get 15 years. I don't know what the good time rule is in Michigan, but I would imagine it wouldn't be any more than 2/3 of the sentence. Some states go as little as 1/3. Normally, with a firearm having been used in this, it's a minimum of 3 years. So I would imagine she's looking at, if it was West Virginia, she'd be looking at about 7.5 years, because West Virginia, good time, it's 3 years minimum for a firearm, and then you kill the sentence at half. But if it's 2/3, she's probably looking at what? I guess it would be almost 12 years, 11 years, something like that. I think would be a third. Well, let me see here. 10 years. Sorry, it'd be 10 years, obviously. Third. So 2/3 would mean she'd serve 10. So she'd still have 7 to go on this. So yeah, she'd be seeing this through the appellate process if it's 10 years, because I don't think they're going to release her. Well, and again, I don't know. Now, she might maybe be eligible for parole, but I think she would kill her sentence at 10. She might have parole eligibility earlier. It might be 3 or 4 years, having served 2 already. Yeah, it's possible that I guess she could potentially get parole, and a parole board could have mercy on her. Do appellate judges in Michigan face re-election, or are they lifetime appointees? That I am not certain. It is the same judge. Yes, it is the same judge. She is handling that case. Well, yeah, screwed. He is screwed in some ways, but remember, James, the affair doesn't come in. Look, remember, there's a likability factor here. So James is going to be okay. So James is not as screwed as we think. Okay, because if he's got a good attorney, remember, it is not the fact that James didn't store the weapon. That is not the issue in the case. That does not get him convicted. Okay, that is not gross negligence alone. This is not an accidental act. That theory does not lead to conviction. Okay, so his failure to go get the gun out of the car doesn't lead to conviction. They have to make a finding in his case, and if his attorney stands up there and learns from this case, they stand up and they make damn certain that whether you believe James Crumbley thought his son, that whether you're holding him accountable under the idea that he had a legal duty to remove his son from school and not go back to DoorDash, or whether or not you believe he had a legal duty to remove all firearms from his house. That is the two things. That is the two theories of case. One is they had a legal duty to remove all the firearms from the house and keep them away from him. Essentially remove them from the house because he intentionally did this. So the idea would mean by having them in the house, even if you took all necessary legal precautions to hide them away, if you knew he was mentally unstable, you knew he was a problem, and you didn't go and do and you didn't take the precaution of removing them, taking them to your parents' house, selling them, getting rid of them, not being a firearm owner because you had a son, that was you thought was a potential mass shooter that was going to go out and harm people. Then in this case, they get a conviction. But it all stems on, and that's what his attorneys have to do a very good job of, is it stems on foreseeability. Eliminate all the BS. Doesn't matter about buying of the guns. That's going to inflame them. That's fine. Concede it. Keep that case narrowly focused on the foreseeability issue, and make sure the jury understands that it applies to both. And make sure they understand how it applies to both. That the legal duty results from the fact that the legal duty was to go get mental health care for him, and that he should have seen, based on the fact of what he saw, what he knew about his mental health issues, and then what he saw on that sheet at the school, that he should have removed them. Still has to foresee that his son was going to do a mass shooting, that his son was going to harm others and not harm himself. On the flip side, kept the guns in the house, stayed a gun owner, engaged in helping his in participating with his son, in being a gun enthusiast. All okay, except if he thought that his son had mental health issues and was wanting to harm others, and he just said, okay, I am going to keep my guns in anyways. I don't care about that. That's an inconvenience, and I'm not going to help him because I just don't care. So it's got to be pounded home by his defense that the foreseeable. And then further, His defense attorney makes me not be emotional at all about it. They need to pound home that is the crux of the issue, and that under the law, you are to presume that my client did not believe that my client could not have foreseen. You begin this case assuming he couldn't have foresaw it. And then everything that comes in, every conflict, everything you're not sure about, every time there's two potential explanations, you take the explanation that goes for innocence, and the innocence in this case is that my client couldn't have foresaw this. You have a counselor at school. You're trying to determine what he thought was there. The counselor is telling him we have a suicidal situation, and you're unsure. You assume innocence. That's what you do in this case. You foresee it. You assume, you presume innocence. Unless it's clear and beyond a reasonable doubt, unless you have no hesitation, waiver, no vacillation, you believe beyond any doubt that he walked in that school and said, my son's a mass shooter and I don't care. And I kept guns in my house because I knew my son was going to shoot up somebody one day. I knew he was somebody that was going to go harm people. And I said, I don't give a shit. I'm going to just keep the guns around. I'm going to ignore them. I'm going to go out and DoorDash, and I'm going to go to the gun range, and I'm going to keep teaching them how to shoot guns, and I'm going to keep furthering that. And I don't give a shit because, hey, I want to lose everything and go to jail one day because I don't care that my son wants to go shoot up somebody. So that's what his attorney needs to be, standing up in front of that jury and really bring it in and hone it in and get out of the emotional bullshit, get out of all the crap that Shannon Smith stood up there and fought emotion with emotion and talked about. It could be you, it could be that, it could be this. That is not the issue here. And yeah, maybe it could be you, but you know what? The issue here is, do you really believe that this individual here would have said, hey, I'm going to keep guns in my house if I think I got somebody that's going to go shoot up the mall, a school, somebody? Does that make any freaking sense? What about this case? Where in this? And that's what she needed to have been standing up there. Where is it? Show it to me. Because every theory of this case runs through the foreseeability test. And if you don't survive it, it's just like in the NFL. If you don't survive the ground, it's an incomplete pass. If you don't survive the foreseeability test, it's a not guilty. Period. End of story. Those two theories require that. And these are how they require it. And that's what the attorney needs to step up there and do. Well, I think he can get a fair trial. I think he can, because I don't think the public necessarily thinks this was a great verdict. So I think it's a matter of who he has showing up advocating on his behalf. I think that and it is more government and reach into the family. That's the scary part of this. Okay, is because now, listen, what this will be grounds again. Your child goes into and does something, and there is a theory now where they would say there's probable cause that we need to take your cell phones and look at your cell phones and your messages. So one of the things I'd suggest all parents consider doing is, man, a lot of cell phones save all text messages. But there is an ability to save space on your phone and have them deleted every 30 days. You might want to consider that, because you don't know how it'll be viewed. You don't, and this is the scary part that Shannon Smith was trying to say, context. They cherry picked and pulled things out of context. Go back and read your texts between yourself and your friends and your significant other and your kids, and just cherry pick some things out of there, right? Take some things out and decide, I want to make you look bad. I guarantee you every single individual someone would have the ability to do that. And that's the danger of what we have going on here in this case. But it ends if we get this case tested correctly in court and the law gets applied correctly and it gets explained to the jury correctly, and we don't have this problem. We do not have this problem. It ends if the presumption of innocence is applied in this case. It ends if we get 12 jurors in there that understand how to apply the presumption of innocence in the case and then understand how to correctly apply the law. So it is the fault of the jurors in one sense, but it's really not the fault of the jurors in the sense that this was a very confusing case. And this was a situation where the law was not clear. They were applying the law in a special way that it wasn't meant to be applied. And the jury misunderstood it and said, "Oh, well, this was a gun access issue. This was not a gun access issue." And Shannon should have made that very clear. But see, she didn't think that the gun access issue was an issue because she thought, like everyone else in the world, that the open gun case on the bed. But clearly, this jury went into speculation. And listen, I've been a juror before. Said it was concurrent by law. The judge don't have discretion. Dave Helm, MLS. What was concurrent by law? What do you mean? I'm not sure. Was he saying the verdict was concurrent by law, or what? Or are we talking about what are we talking about? Concurrent by law. It will be. Oh, I see. Oh, you guys are talking about sentencing. Okay, good. Okay, yes, MLS. Okay, now I'm understanding. I was a little behind in there. Yes. Okay, good. So it is concurrent by law. Fantastic. So that means 15 plus time served already, which is like 2 years and 1 month. Did he say? No. It's not. Concurrent means no. That would be consecutive, Angela. So that would mean concurrent means. It's basically 15 years. She will get 60 years, but she will serve one, but it will all run under one sentence of 15. So she'll get credit for each. So she'll be sentenced for 15 on each count, but she'll serve one count. And while she's serving that one count, it'll serve for all of the other 15-year sentences. Question though, did he say how long in Michigan it is that that good time kicks in? Like, when is her parole eligibility on that? I'm assuming there's probably a mandatory minimum due to the fact that it was a firearm offense. But did he say when she would be up for parole? Because I mean, I'm thinking 3 years might be when she's up, so she could be up for parole like next year. I mean, in theory. James' ex-wife is apparently testifying. Really? Oh, I didn't know James had an ex-wife and a child with. So what the hell is she testifying for? Is she testifying against the state? What the hell is she allowed in for? I guess what? That he's an irresponsible parent that doesn't care about his kids? Oh, that's ridiculous. I mean, that'll be interesting. Like I said, it'll be interesting to see how it all plays out. The good news is I hope this means she doesn't do much time in the penitentiary, but it doesn't help her at all. See, one of the areas, and it's kind of becoming clear now why those parents were so excited. See, you got to remember, there's always a financial goal end in mind. The reason why those parents were so excited is because I believe each one of those is suing the Crumbleys, and I know that this finding, because it's a higher standard than the civil, that this will basically allow them to go ahead and have a judgment entered as far as there will not be another trial in regards to whether or not they're liable. It will only be a matter of how much the damages are. Parents are civilly liable, but not criminal. Yeah, I agree. I mean, listen, you can make a case about civil liability here. Yes, because it's a lower standard. It's a lower standard. And yes, but that's what Bruce Rivers was saying, is that it's civil liability all day, but not criminal. Criminal gross negligence. This was woefully short of that. Okay, so here it is. So he said Mac had maximum of about 10 years left to serve. Okay, 80. There it is. That's what I thought. I thought I'd heard somewhere that it was like she was going to have to do about 2/3, potentially do 2/3. So does she have the potential though for a parole date earlier than serving 80%, or is this one of those situations? Is Michigan one of these states that says you don't get credit for good time, or not necessarily, you don't get any potential for parole earlier? Because sometimes it's like if she serves it, she's going to get good behavior credits, which is why they would say she gets out in 10 years, get 2/3. She kills her sentence in 2/3, but a lot of times there'll be a parole date that will come up earlier than that. So she's guaranteed out in 10, but at 3 years, she could go before the parole board. Now, whether the parole board would say, I'm going to let her out, I don't know. Gotcha. He has a son. Okay, so let's see what we have here. He has a son older than Ethan, and he never paid child support. What? Oh, jeez. How does that have anything to do with him believing his son would do a school shooting? I mean, that's nuts. I mean, again, this case is unbelievably about character assassination, and this judge, for allowing this garbage in, God, it's scary. Just chilling. I just got to chill thinking about it. Dave Helms said he had not scored it out, but the judge don't have to follow the scoring of the crime anyways. In principle, she could sentence her to time served. Oh, okay. Okay. That's very interesting. Very interesting. So we'll see what happens. I felt in a way, I felt that judge thought a not guilty was coming, because I remember when she said, I want everyone sitting down, because I think she really thought that jury was going to come back and acquit, and she was protecting the courtroom from having an outburst. Jennifer Crumbley will be, absolutely, she'll be on protective custody because she harmed children, and prisoners are not going to like that. There's no way. I mean, maybe they view this a little different because it's a negligence issue, but I think she's too well known in the press. I think these prisoners would love nothing more than take her out. But I mean, I think that I think it'll be interesting to see what the judge does at sentencing. I mean, I kind of felt like the judge was sympathetic to Jennifer Crumbley to a degree. Obviously not enough to give her a fair trial and make sure none of the garbage came in. But I think she seemed to be a judge that, gave the prosecution a lot of deference. Let's put it that way. Especially Mr. Keys. I mean, he seemed to run her courtroom. I mean, when he said jump, she jumped. When he said this is what it was, it's what it was. And then I was shocked at how Shannon just something was wrong with her. I don't know what was going on, but she just seemed like she would give up on some of these arguments way fast, and she was allowing herself to get pushed around. She looks 10 years older than she did when she was arrested. I can't believe the weight she put on. Most people don't go to prison and put on weight. Look at Murdoch, man. That dude lost like 150 pounds. She put on all the weight Murdoch lost. And I'm sitting there thinking, I mean, I have never heard anyone say I'm going to jail and eating the good cooking that's going on in the jail mess hall. I'm assuming maybe she must have access to some commissary or something. I don't know. She must be stress eating or something, honey buns in there. But I mean, you only get so much a week. But I was just stunned. I thought that normally people go in there and they lose weight because the food's so terrible. You're under stress. You don't have access to snacks and food like you would at home, and you're not eating a lot. But my gosh, I mean, I was very surprised by that. I never thought about that. Yeah, she probably that could very well be. Well, let me ask you this, man. So, again, obviously, I'm not a doctor or anything like that, but wouldn't it still require her to be eating a lot of food? My point is I don't think they really have access to a lot of food in there, to gorge yourself on. I mean, unless it's water retention. But then, even then, I mean, again, I don't know. I've never been to jail, so I hope I don't ever find out. But, yeah, well, she's had a very tough time. I can only imagine. I mean, I was thinking about this yesterday and thinking to myself, you're driving down the road, and a lot of cases, when I'm watching cases and I see this, you kind of have that feeling like, oh man, I'm comforted by the fact that I believe for the most part, a lot of the cases I watch, choices were made for the person to be there, right? And in this case, it wasn't. I mean, the state would lead you to believe it. But in truth, this is a woman who went to work. She was going along. She had a son that was, a little weird. but smart guy, struggling with his school, not brushing his teeth, raising some hell. They were fighting with him and having typical things. Never foreseeing that day when she drove to work or drove him to work that anything was going to happen in her life that would land her in jail for the next 2 years. And then possibly in jail. I was thinking yesterday it would be possibly up to 60, but now up to 15 years. Nothing that was going to just totally upend their life. And then next thing you know, she gets a call for the school. Even then, she's not thinking to herself, man, she's thinking to herself, oh my God, all right, we're going to have to get a counselor. We're going to have to do these things. And that's what's crazy part to me was like her reaction, going to her brain trust and sending around the math worksheet. That was all indicators of a parent that's concerned and vigilant and worried about her child and worried about trying to figure out how to deal with the situation that her child's facing. Not some parent that's ignoring things. But anyways, and then next thing you know, she finds out there's an active shooter. She finds out it's her son. She's in handcuffs an hour and a half, 2 hours later. And then from that point on, her whole life comes apart. And she's in jail. And she's sitting there thinking, holy shit, it was not because of an intentional act. It wasn't because of a choice she made. She did nothing. It was just her kid went out and did this. And oh my God. Well, yeah, I know when you said antidepressants, I know the antidepressants can absolutely, I've heard of that, right? But the thing that disconnects with me is the access to the food that would have allowed that to happen. I just thought, man, I've never seen, very few cases have I seen, although Courtney Clenny, it looks like same thing's happening to her down there in Florida. I saw her make an appearance, and they probably have her on some antidepressants and stuff because I know she had some mental health problems that was part of her case. But I'm just thinking to myself, what are they eating the jail food is not ever reported to be gourmet or good or something that you're going to overconsume. You're getting a tray of food. Commissary is limited. It's very expensive items. So some say, well, you can get 50 or 60 bucks a week. Yeah, 50, 60 bucks a week sounds like a lot. Not when it's $10, $8 a cinnamon bun or whatever. They price it high to limit the amount of items that people can have. And I don't really look at Jennifer Crumbley as the queen of the block who's out there, working a hustle to acquire a bunch of commissary items. So I'm sitting there like, how in the world how did she go the opposite of most people? But perhaps it's water retention. Perhaps it's, eating, maybe just eating ramen noodles. I know those are terrible for you. Just eating the wrong stuff and then being sedentary and not moving. And then on top of that, taking antidepressants. So it's a very, very possible explanation, but it's a concerning case. It's definitely a concerning case. 23-hour isolation. I would say you're probably right because I think they are in their cell for like 23 hours a day, and then they go to a little cage. And again, it's something I never want to know about or experience. I hope I never do. Knock on wood. I hope. But as I've always told people, I've told my kids, I've said, unfortunately, there's one thing we do every day that could land us in there, and that is operating a motor vehicle. And it doesn't always involve, at least like in my state, they have put on some really strict distracted driving laws. So, you need to make sure you lock that cell phone up because now in my state, if there is an accident and there is an injury, it is now law that they have the police officer now has the right to confiscate your phone and look through the phone to ensure that you were not texting or in this case, it's pretty strict. You can't have had. It doesn't really say. There's a little vagueness on the aspect of whether or not listening. You can be listening to something, but you can't be watching something. So I know some people will watch YouTube, listen to YouTube. So at least in my state, you got to be aware if you have YouTube up and it's on the phone and you can't prove to the officer that it wasn't being watched, that can be used against you, and you can now be charged with a felony. And if there was an injury, up to 3 years in prison. And if there's a death, I think it's up to 15 years, I think is what it is. And then now, if you're caught on your phone, it's a misdemeanor. It used to be a traffic offense. It's now a misdemeanor, punishable at the same level as a DUI. And I think if you get 3 of them, it's a felony now. So it's pretty serious business. You know. All right. So let's see here. Another question here. Do you think James, the lawyer, will put all the blame on Jennifer Crumbley like they did? No. See, this isn't a situation. And that shows a misunderstanding of how they want to apply this. Is, to me, I don't think they need to blame anybody. They need to get the point across that it was not, the negligence in this case does not merely derive from the fact that they didn't secure this weapon, or that this weapon wasn't stored away from him. I mean, obviously, there is no requirement for him to store it in a box. So if his testimony is, I got it out of the car, I put it in the room, and I stored it where I normally store it, even him not putting on that, whatever that little lock was, this wasn't accidental. It still requires them to foresee that he was going to be a harm to other people. And that is the bridge that has to be crossed. That is what the appeals court held. And that is what the state's obligation was to prove. So his attorney would be making a mistake, in my opinion, getting caught up in trying to transfer blame here, because it isn't about that. To me, it's, all right, we're concede the gun was in the house. We're concede Ethan could have potentially had access to the gun. Okay? But the state's case here is they should have removed that. And the only remedy to this is remove it. But the reason why that's the only remedy is because they had the thought that he was going to be a harm to other people and that they were doing nothing about it. That's just ridiculous. You cannot get there. You cannot get there with the evidence that they presented in this case against Jennifer. And I don't believe you're going to get there with James. I don't believe you're going to see a father that was crying and sobbing in the police substation. You're going to tell me that that was a man that would have been okay with his son doing this? He was devastated over this. That's ridiculous. That is ridiculous. At the same time, we get, I know, like the Teslas, they got the big giant, I got a freaking iPad. I mean, it's not, but it looks like an iPad tablet in there. You get a ticket and point. Yeah, in West Virginia, you used to do that. It used to just be a points, but now it's a actual, I mean, it's a crime that would show up on a criminal background check if you get convicted of it. And it all derived out of a driver who was on his phone. He checked the weather, looked at his phone. They were able to prove it. I don't know if they proved it through his statements or just looking at his activity, or they looked at his activity and got his statement. But he basically admitted, I looked at my phone to check the weather, looked at it, looked up, and there was a biker. And the biker was not where he was supposed to be, but he was, riding in the road, and this guy didn't see it, and he hits the brakes and runs into the back of the biker. Biker gets thrown off the bike, hits his head on a rock, and he dies. And of course, they charged him with the laws that they had. He was found not guilty. The family went went and was upset with the outcome based on the way the law was applied that was on the books, and they started working with the legislature, and now we have this law that is now dealing with it. It's very much what should have happened in this case, because there was no law adequately dealing with the facts of this case. If they want to make that a law, my contention is those families would have been better off working with the legislature of Michigan to expand the manslaughter law to include language that properly deals with this. And then they could have gone after the Crumleys in civil court. But here's the problem. Again, like I said, I was touching on this earlier. The attraction to the criminal prosecution here is the fact that this now allows for the civil liability to go forward. And again, I'm not certain, but I don't know if this would be something that they would, obviously the Crumleys don't have much to pay out, but I don't know if homeowners would be one that they could sue in this instance, if this would be some sort of a thing that they could try to go after that. Obviously a lawyer would have to look at that, but the fact the gun was stored in the home and And if that was somehow attach out and be something that they would say was able to pay out damages, I don't know. But I know these families now have the right to sue. I know that I don't know if this would attach into the school or not, but I know it helps that fact. I know those school officials are still going to be up for having to go through a civil case. Most people over here in England either have their phone or their e-cigarette in their hand. So many accidents everywhere, I'm sure. Distracted driving is a real thing, but it's my point in bringing it up is driving is one of the biggest ways people find themselves involved with the legal system. And, you know, so you got to be careful. No, I don't think they have any qualified immunity. I don't think that's why they chose not to charge them. The reason why they didn't end up charged, according to what I heard, and maybe you've heard something else, so I could be wrong on this, but my understanding, and it's what the prosecution alluded to, is the way the school officials avoided being charged is the state was claiming that the Crumbleys withheld information from the school officials. So the school officials had incomplete information. So their conclusions were okay. No, they're not. I don't believe the school is covered by any immunity on being sued in this case. I don't think, or maybe I don't know. I think that would cover them. Well, I think that could apply, but Mads, I think that if they find a certain level of negligence occurred, I don't think it protects them from that. So if they can find, like, for instance, if they would have charged these school officials and said these school officials flat out should have saw that sheet as indicating that a school shooting was going on, and that now, in my opinion, it was grossly negligent to have not suspended them. Now, I don't know what the school rules called for. You know, it was not criminally negligent, but it was negligent to the school. In other words, they created a risk if they didn't follow their own disciplinary guidelines. Now, that is a case that should be made in civil court. I assume lawyers are going after it, but that's the honeypot of money, is suing the school system and suing the school board and suing the local government who's responsible for all of that and saying they were derelict in their duties. The two other people on that meeting about that match, I agree with you. Well, I agree and I don't agree because, again, I'm under the inclination when looking at this that this was not, when you look at that sheet, and we're pulling it up here. I think this is it. Yep. Okay. All right, let's go. So when you look at this sheet, right? I don't necessarily agree that looking at this would tell me that a school shooting is imminent necessarily. Obviously, if you saw the journal and you saw other things and you saw this, you would think that. But with the limited information that was available to all parties involved in assessing this, I can understand why they would have believed potentially this was a kid wanting to harm himself. However, the graphically violent things that were written on here, to me, still should have risen to the level to say, we got to discipline him. You can't write violent things on there. It's concerning. He's getting suspended, 3-day suspension, 1-day suspension, whatever. Confirm with us that you're getting him help. And I feel like at the same time, it wouldn't have been to say, you know what, we want to make sure he doesn't harm himself here in school. We may search him when he comes back to school. And honestly, I would have searched his book bag too and just said, let's make sure he doesn't have a gun before we send him back to class. I don't want him shooting himself in the bathroom. Ethan, do you have a gun on you? No. let's search his book bag. I think there was definite reason to search his bag, and I think all those things could be considered. But again, I don't think you could say it was foreseeable looking at this sheet that he was going to be doing, that he was going to be doing a school shooting. I mean, but again, it's this line here: the thoughts won't stop. Help me. That the police tied in to say he was hearing voices. Notice he doesn't say I'm hearing voices. So that's why the crap about I'm hearing poltergeist and I'm seeing things fly off, this does not in any way resemble that. This is just saying the thoughts won't stop. He's thinking about, but to me, when you read that, he's got a gun. The thoughts won't stop. It looks to me like I now know, if you really look close at it, it's not probably him. But when you look at it, it looks like he's got blood coming out of his head. Or it could be derived at it, construed as that way. And it looks like he's got his hand up. It looks like he's drawing something that would indicate he shot himself. Now, obviously, the two wounds that are in the front, I mean, again, if you're really diving in and analyzing it, after knowing what we know, but when you don't know what we know and you see this, you're like, the world is dead, blood everywhere, I see bullets, my life is useless, the thoughts won't stop, help me, drawing of a dead person. Okay, it appears Ethan is, and again, that's exactly the course they took. I don't think there's anything crazy about thinking that this was about harming himself. I just don't. And I could be wrong on that. I could be very wrong on that, but I don't think it was an incorrect assumption. Well, again, my assumption is that it was probably his dad had it in his bedroom. I think he said it wasn't locked away. It was like if you look at the family bedroom, the pictures of the bedroom, it was like an open cabinet that it was in there. So listen, his dad probably, I thought they said his dad dropped him off at school, but I don't know if it was Jennifer or his dad, but listen, that was a small house. Ethan gets up. He could have gone in there while they were sleeping and gotten that gun right out of there. But again, remember, that is not the issue. The gun was in the house. That's an intentional act. Every indication is in this that, and when he does a mass shooting, that is an intentional act showing intentional planning. Remember also that the state held that he was a diabolical criminal, unlike any other criminal ever charged as a juvenile, to the degree that he deserved life without parole, because juveniles in the United States after 2013, the Supreme Court held you have to have the Miller hearing, and it should never be a practice to lock up juveniles for life without parole, because there's a wealth of evidence that suggests that the brain of a juvenile is not developed fully as far as seeing, being able to see the future, being able to assess consequences, and that development of the brain of a juvenile doesn't stop until 25, and that even if you make a bad decision at 11 or 12 or 13, you still have the ability to be rehabilitated. There's still an ability to change the outcome of what their life will be. As a result, you should not take away the hope that you can get this kid help, and at 25 years down the line, when he's, 37, 38, 39 years old, if he's given help, that he can't get out. The state held that no, and their reasoning for that was that he was such a diabolical criminal that he could trick the parole board, and that he had tricked everyone in his life, and that he was on a different playing field than everyone else. So if that's who you have in your house, and he's tricking everybody, and he's such a diabolical criminal that he's worse than any other juvenile ever, and that he should be held accountable like an adult, then how in the world do you come to and say, well, yeah, it's beyond a reasonable doubt that the Crumbleys would have foresaw that they had this individual living with them? No, they wouldn't have. And since owning a gun wasn't illegal, and since there wasn't a legal requirement to store the gun, which all of that was brought up, but I mean, all that's known. And there isn't a requirement, and this wasn't an accidental act. In other words, this wasn't a situation where the gun wasn't stored properly and Ethan picks it up and mishandles it. As a result, whether it was stored properly or not, that's the reason why that would not apply in this case, because whether it was stored properly or not, he intentionally went to get the gun to go do an intentional act. It was not accidental. Thereby, even if the gun was left out sitting on the counter, it loses it at that point. The only way the causal effect of leaving the gun on the counter travels with Ethan, and that the Crumleys travel with Ethan to the school and become responsible for his actions, is if they could have foresaw that he was in such a mental state that he would have done a mass shooting, that he wanted to harm people, and that they had ignored that they knew that, and that they were living around that, and then they just simply didn't care. And that's fucking ridiculous. And that's why Shannon was arguing so passionately, but she just didn't make the argument clear and concise enough. But it was ridiculous. It was ridiculous. I mean, there's just no way you come to that conclusion. And then when you look at the messages and you read the messages and you look at how they're interpreted, but, you know, it was just not, I don't know. It got lost. Jennifer left before they both left, so I think it was James. Yeah, okay. So James is in the shower. Ethan could have walked in and got it. James could have still been asleep, and Ethan could have been up. Remember, Ethan's talking in his diary about, or his journal about, I'm ready to do this. I'm ready to, you know, like he's been planning it. He knows he has access to the gun. He knows where the gun's kept. He sought the trust of his parents, and it wasn't negligent for his parents to have trusted him. It's only negligent if they had a belief that by trusting him, he was putting others at risk, or that he had deemed to put others at risk. So, let's see here. As much as I hate Ethan, I agree with you. I think he should have had the possibility of parole. I think parole should have been a possibility, should be a possibility. I mean, even in the worst offender, I think parole should always be a possibility, period. I think life without parole should never be. Now, that doesn't mean they ever get out, but I think it should always be part of the process, that it should be being reviewed. And what that does is that gives encouragement to our justice system to make sure that we are also ensuring that while it's not a comfortable life, it's not a free life, but it's a life that says we're always trying to make these individuals better individuals than what they were when they went in. And we have to do that, because we can't have people come out being worse than what they were. Hold on one second. So let's see here. The state don't mind arguing one thing in Ethan's chair. I know, and that's what bothered me. They did exactly that. That's what bothered me greatly. And the state in this case, it's very troublesome. It is extremely cumbersome. He can rebuild. He can, well, and if he can't rehabilitate, again, you're not getting out unless you got people that can assess that. But see, by allowing life without parole, we don't require necessarily to have that assessment happening all the time. So we throw them away, lock them without the key. But that should be an assessment at every parole hearing. And every single one of these people should walk in, and there should be a plan of action that should be saying, we're going to get you to, like, there should never be a sentence, in my opinion, longer than 25 years in our justice system. That doesn't allow parole to start happening. So even if you get a 60-year determinate sentence that, technically speaking, the calculations would say it's the rest of your life. No, 25 years or whatever, 15 years. I think 15 is probably fair. At some point, you start to get reviewed for potential eligibility for parole. That when you go in, there's a plan. We give these people something to do other than become better criminals and attacking themselves and creating a little criminal enterprise going on behind the bars. You gotta have something to work for. Doesn't mean they're getting the trappings of life. Doesn't mean that they're living in an 8x10 cell with another individual doing your bodily functions in front of this other individual, having no freedom to choose when you eat or when you do this or when you do that. It's not fun. And exactly correct, Matt. It encourages prisoners to behave. And that's the point. Like the people that get upset and say, well, they don't deserve, they need to be punished. Yes, they do. The punishment is in a restriction from their family. Every person they love, they don't get to get out. They don't get to say, hey, I want to go to my family member's house and go see them. Family member in the hospital, they don't get to go see them. Family member dies, they don't get to automatically go to the funeral. They miss out on that. They don't get to go see the latest movie. They don't get to go to McDonald's anymore or go out on a nice restaurant. They eat the same garbage crap every single day. They're not getting that. Maybe everybody should have a parole hearing date, but some people. I agree. Listen, I agree with that. But what I'm saying is that every single one in there needs to have the idea that they're working towards something, and that's what they should be working on. And if they have to spend a lifetime working on themselves, it may never make them well enough to survive in society, but it might make them better to be prisoners within there, and perhaps maybe we get them back to a contributing level. But the point is, they shouldn't just be allowed to just sit and just sit there, and have no hope. You can't take the hope away. And I understand they took someone's hope away, but here's what I say to that, right? You hear a lot of victims testify, come in court and say, you took my loved one away, right? And I always think to myself, obviously, I've never had someone do that. I hope it never happens. I have someone I love get taken in that way. But I've also thought, what would I say or do in that instance? What I would hope is that when you take someone's life, whether it's intentional act, unintentional act, but when the life is taken at your hands by an action or activity you did, you now become beholden to their memory. And for me, if I had someone take my life, I would hate to think that my memory now is tied in to say that the person that now lives in place of me, which is the person that took my life, that all he ever becomes is a prisoner in the prison system. Life never becomes more than that. And he becomes the worst SOB in the world. I would like to think that my life got lost, not to create a prisoner, but that it got lost, and as tragic and unfortunate as it was that it got lost, but that it got lost for a greater cause. And maybe that cause is you have an individual who finds some sort of salvation in their life. They find some sort of resolution for their issues, and then they end up doing good for others. So in my life being lost, a person becomes better and greater good becomes spread through them because they go to prison, they get rehabilitated, they deal with their issues, and they come out on the other side. I hate to think of a system that says, you take my life, and all that comes out of it is vengeance and the same thing they did to me. That a lesson doesn't get learned out of it or out of my loved one. And I certainly would not want them to not be punished. But I want a system that doesn't just punish them, but rehabilitates them and allows them to live in memoriam of the individual they took. And that should be the thing that they walk away with. They need to come to that. And that should be one of the criteria for parole is, do you understand you took a life? If you took a life, you robbed somebody, you victimized somebody, you hurt that person, right? They experience pain. But now you carry the burden of making. Why did they experience that pain? Did they just do that so you could experience pain? Boy, that's heinous. I don't want that. No. That victim experienced pain because out of that pain that they experienced, you learned something. Now you need to go out and you need to pass on the good to others. And you need to figure out how to be a better person. And then in memoriam to that person you hurt, go out and do good things to others. And we need to have a system that supports that. And the parole system will support that. And as a result, society becomes better when we have a system like that doesn't take somebody, put them in, make them worse, send them out, and then they victimize again. So now I've been a victim. And then, what does that do for my memory? Or if I'm a victim of a crime that doesn't involve my death, but still, my suffering led what? So they could go behind bars, learn how to make other people suffer more, leave, go out, and make someone else suffer even more, maybe even kill somebody. And you think that's justice? No, the justice system, that's why I said justice is a process. It's a process that continues working, even when the court system lights go off, even when the appeals are extinguished. Justice works when we put the people behind the bars and we start making them go through their process, because they have a process to get to. And then when they parole and they get out, the result of our justice system walks with them. They are a culmination of the efforts. When they walk out in the pine box, we say, okay, was that successful? No. The person went out in the pine box. Did they add anything back good into society? No. But the measure of justice should be, how well did we put that person through the process? We ensured that they did what they did. We ensured we had the right person. We ensured our laws and processes were followed. Jury certifies that, finds them guilty beyond a reasonable doubt. Judge sends them in. They go in. They get their punishment and they get their rehabilitation. And when they leave a better person. And they leave. And the measure of justice is not in how much pain we cause them because of what they did. That to me is not good. It is measured in, what did they do afterwards? Did our system lead them better than when they went in? And were they able to go out and contribute something after the fact? And if they don't, if all they contribute is another crime, we failed. That's the measure of justice in my eyes. And it's the system that we should strive to have. And in America, we have a system that has great potential and really is extraordinary in some of the principles that it puts forth. But it also has a lot of attempts to try to subvert the process, get in the way of it. And we have a prison system right now that incarcerates way too many people for way too many crimes and doesn't in essentially because of the fact it's funded privately and for profit. They're not incentivized to create people to contribute good and not come back. It's like they want to create business. So it's in their interest to send them in, make better criminals, and 3-4 months later, 6 months later, 18 months later, they commit another offense. Recidivism rates are through the roof in America. And boom. So is Ethan no, he's in adult prison. Well, no, I believe even that day they said they were taking him to the adult jail. I think he's in an adult prison, but I think he's in a lot of times in these adult prisons, they have a wing where they will put like the younger inmates. Eventually their age up to where they're at, where they're going to go into the general population. Maybe the parole hearing can just grant them a nicer prison to live in. For the worst of the worst, you still reform. Yeah, well, again, the parole hearing should just be an assessment of their progress, and that's really what it should be. And then when they leave the parole hearing, they should leave out with, this is what you have to work on. This is what we saw. These are factors we're looking into. Continue working. And then we believe, there should be a recommendation of, all right, how much time do we need before we can reconsider you again? So if the panel of experts that are assessing that prisoner says, I think it's 5 years, he needs 5 years before we can take a look and see what progress he's made, 5 years. And then at that point, do we need to lower his, as part of that process, does he qualify to be in a facility? And again, the facilities, see, here's the thing. One thing in this statement I want to address: grant them a nicer prison to live in for the worst of the worst who still reform. You have just hit on a very strong weakness in our prison system. It's the grouping of prisoners based on yesterday's crime. It should not be grouped that way. That tells you the overall flaw. By putting murderers with murderers and robbers with robbers, you're just inviting the idea here that you're going to have, again, you're going to encourage worse and worse. And I understand there's risks and stuff. You don't want to be putting a guy in there that's serving time for forging checks with a murder. But what we really should be classifying our prisoners by is, yes, we want to classify by the offense type because we don't want to put people at risk of being victimized. But we also should have classifications based on needs. So if you have individuals with certain, it should all be assessing their needs, their mental needs, and what they need to work on. So that when they're moving to a unit, this unit might specialize in depression or might specialize in, victims of abuse as a child, and that they can go there and work with doctors and work in a supportive environment. And it should all be conditioned and surrounding around helping them deal with their issues so that they can be working on that. And then when they get there, that might be a portion of what they need to work on. And they say, okay, they completed this. So now they need to go work on this so they can move to another facility or maybe within their facility. I'm not saying there shouldn't be a maximum, but the facility should really be about meeting the needs that they need to have that can help them get through the issues that they have. Now, like you said, there might be some people that there's no way you're never going to, some people, especially sex offenders and stuff, you're never going to get them to stop doing what they're doing without medication or something like that. So, maybe something that you may say, well, they're not fit for parole, or their parole might require certain restrictions, or they might be required to, whatever. But the idea is classifying them about their actual rehabilitative needs. I don't remember. If prisoners can reform, they should be able to get out. I was thinking about unreformable prisoners still lives. Oh no, I agree with you. And what I'm kind of talking about the same thing where I'm saying but they should all be like where they go and house should be at a level of dealing with what they're working on. So when they go before a parole board or a parole team, it should be, hey, we're going to work with this issue or these type of issues. And like I said, their journey through the prison system should be about reforming themselves, and it should be about reform. Absolutely. So I agree with you. But in then assessing their ability to reform to a degree that they can return to society. And that's why I think parole, I think it's really arbitrary to say, well, a judge gets to determine based on the severity of the crime when they're reformed enough to get out, because how do they know? At that point, it's not normally they normally don't do a workup on them. But I think when they enter, they do a mental workup. They do different things. I think they need to do that. And that should be part of the parole process. And it should be, reformative correctional process where you go in and you're not living a free life. You're not getting the trappings of the world, but you're here. You're here to work on yourself. You're here to make yourself better. It's like when I have to get on my sons about grades, and I explain to them, all right, we're removing the video games. We're removing the access to, not completely access to cell phone, but we're removing access to certain apps and things that are distractions. We're not saying you can't ever do it again, but right now your grades are in the dumps. So what I'm doing is I'm removing the distractions. So once you put enough time towards your school each day, and I know you've done it, then I'll give you some time back doing some of these things. And that should be how it should be in there. You've got to spend time working on yourself. And when you meet certain benchmarks, you get access to a TV in your cell. You get access to this. You get access to that. You get some commissary points. For those that don't have supportive families at home, you start getting some privileges back because you've put in some work and you started to show improvement, and we've seen that. And that's what we need to really have it towards. The problem is you would get a lot of resistance. Well, here's what's really going to happen. I mean, you're going to hear in the news people coming in and say, "Oh, it's not vacation time. You don't send them there. You don't give them. You don't give them things. You don't make it easy." And the funding for that's coming from the prison industrial complex. They're making a lot of money on prisoners going in and not getting any reform at all and coming out worse, because what they want, it's a mill. They want to refeed them back in. I mean, you've seen judges. I think there was a judge up in New York. They were bringing juveniles in, over sentencing the juveniles and sending them to facilities and getting kickbacks from the facilities. I mean, a lot of the prisons now all over the country, federal and state, are converting over to being owned privately and they're for profit. And they don't make money off their guards. Guards are an expense. They don't make money off the food that's provided. They don't make money off the services that are provided to prisoners. They make money off of the prisoners being stored thereby, and they make that money from the state. It's a huge racket, and the more prisoners they have, the more money they make. So their goal, when you put profit into this, it's an area that should be not an area for profiting, because there should be not a financial profit when it comes to prisoners or corrections, because the profit that we would get from this is human profit off of the fact that our system should be putting people in and putting better people out. And the profit we get from that is what they contribute when they come out in a positive way. And we take a loss on that prisoner when they come out and they do another crime. And it shouldn't be 3 strikes and you're in jail forever. There's a reason why that came across. There's a reason why that was heavily funded. There's a reason why that was put in play. Because that means now the prison industrial system has an individual that they get money on for the rest of their life, or as long as they're alive. So they have every incentive to keep them alive, but they have every incentive to keep them alive with the minimum amount. And the goal of the prison industrial complex is not for them to come out and not commit a crime. It's for them to hit the 3 strikes and get them in there, and now they got a lifetime cash flow on that prisoner. And that's the dirty little secret. And every time somebody tries to come out and say we want to try to reform and we want to try to get the justice system where it should be and talk about trying to make, talk about reforming people alongside punishing people, big money is going to flow right in, and every politician or every person that's going to be responsible for this is going to be painted as soft on crime. And they're going to roll out a victim family, just like Happily was going to come out and say, yeah, I lost my brother, I lost my son. And, how can you want to some guy that got released, a judge does some sort of, explorative justice or sentence or something, and it doesn't go right, and it's going to be right on there. So nobody wants to do it. Nobody wants the responsibility for it. But it's all because we don't get our justice system reformed until we take the profit out of the prisoner racket that goes on in every state, most states, and federal system all across. It's why the federal system is owned majority private. Why do you think there are so many deaths going on in there? Why do you think there's so many problems? Because they have stripped away a lot of the things that would be necessary to keep people safe. Over here in England, we have a section for pedophiles and vulnerable people, and then other sections are murderers and just general crime offenders like burglars, etc. Yep. Well, again, and that's what I say. I definitely do not. I'm not saying that there doesn't need to be separation or anything like that, but I believe that there's got to be there should be classifications based on the needs of the prisoners, and they should be on a reformative plan. And when they get in there, that should be their focus. And it should just be, again, you give people hope, people are going to act better because they're going to want the chance to get out. They're going to push forward. You're going to be giving them resources. You're going to be, again, it's amazing to me how it's missed all the time when we say, well, yeah, we let them out, but we make sure that their felon goes on every single job application, and they can't vote, and they can't do this, and they can't do that. They can never get out from the pack. But there's a reason why. Because every one of those laws is backed by a whole gob of money from prison industrial complex who wants it that way. Because they don't want the prisoners to be better when they get out. And they don't want society to view them as any chance of being better. Because what they want them to do is get out, commit another crime, and get back in, because the moment they re-enter the system, the money starts flowing back to them, and they don't get paid unless people are breaking the law. That's why America right now has one of the highest prison rates out there. And that's also why we have to watch the system, because then that's another reason why you see the system of justice the way it is. It gets designed to where they want to get people and convict them. They don't want them getting found not guilty, because not guilty is a loss of money. That's just how it is. Chris Watts can't be rehabilitated. That's true. Yeah. Well, I would agree with that. I mean, I think what he did is terrible, but I wouldn't say you couldn't rehabilitate him. I don't know. I don't know what drove Chris Watts to do what he did. What he did was horrific to his kids. I can't even imagine it. I have a 4-year-old, which I think was the age of what he did and described doing is beyond words. But here's the thing. I don't know what drove him to do it. I can't say whether he could be rehabilitated. I don't know. Maybe he could. Maybe he could. But here's the thing. His time is better served thinking he has a chance and trying to figure shit out like that. And the worst case scenario is we get a great understanding of what made him tick, and he has every incentive to provide that information because he thinks he's got a chance to get out. But I agree with you. I would be less inclined to let someone out like Chris Watts, who did what he did, ever be out again, because what he did was horrific. But listen, we are defined by how we treat the worst of us. And when we show compassion and we give him a path, maybe never, and again, as Mad said, he would probably be a better candidate for, he works hard and he goes from a prison where he's got all these restrictions to he gets a better life. To maybe he gets to live in like a lower security prison at the end of his time. But maybe we find out that there really was some sort of problem or something that he works through, and maybe he can get out and help others and make an impact for others to help them not do whatever the hell it was that drove him to do that. I don't know what the hell drove him to do that. I can't understand. That is a case that has kept me up at night, just like mind boggled. Like, I'm like, how in the world do you think doing what you did there in that case, killing your daughters and your wife, is going to lead you to a life with that lady? How did you think that putting them in the oil drums out on an oil field wasn't going to one day get discovered? Like, where did that become a solution? And I've always thought there had to have been some sort of thing where it had to have at some point been impulsiveness. But he said to the police he planned it. Like, he'd been planning it. And I'm like, what in the world? Like, and impulsively, even if he impulsively kills his wife, how could he ever do that to his daughters? I don't know that she helped him do it. I mean, I remember I watched Armchair Detective, and I watched a lot of his stuff, and I watched him see the kids, which he made a really good find with that. I've watched and watched. I was not doing any YouTube stuff at that time. I was just watching with him, and would sometimes go in the chat. Not on, obviously, Justice is a Process was not I was in there under my real name, chatting away and watching that. But I've always thought that was Chris Watts walking out to his car. Now, I always found it interesting that the back door was triggered. I know I found it interesting that the house was so clean that there was a lack of really anything. I don't know. I don't know if she helped him. I would believe, my theory on it was that if he was going to have help doing this, it would have been someone she knew helped him. And my theory always was her phone ping near the house because she was like driving near the house to see what was going on. And check on things, or, I know her phone did ping near the house, but I always felt like somebody pulled up to the back of the house, because I found it hard to believe when you watch that video of him loading the truck. It looked like the kids were there. So I'm inclined to believe that, you know, I don't know. But I always found it suspicious. I remember there was evidence that there was like tire tracks leading up to the back of the house. So I was inclined to believe that he had some help that day. Who helped? I don't know. I always felt like she was like, I always felt like she was, um, like maybe it was her that pulled up to the back. Um, and I just don't feel like she was on the camera. I think that if she was there, I think her role possibly. I always found it interesting, the idea that, because I never understood. I'm like, what's the magic of putting him in the drums? So my thought is that if she helped, I think that, my opinion is I think that she was going to put this is what I've always thought about this potential was going on. Somebody pulled up to the back. I don't know if it was her or helpers, but I always felt that the body was meant to drive in that car. The girlfriend was going to drive it. She was going to have the body in the car because they needed to have the body found in the car. That, essentially, they get in there and they can't get the cell phone unlocked. So they take, and the girls, I don't know if he offed them at the house or not. But I think that, in my opinion, the girls got up, they see her there, they know too much. And my opinion is that, it's possible that, at that point she helped get the body out to the truck when it was pulled in, because I just don't think he could have got the body was heavy. I think he gets the truck out, they put it in, or it went, or she went in her own car out the back. But I think there's to me something about the back. I think she pulled up, the back door was triggered. I don't believe she was walking out to her car. I don't think her car was parked anywhere near there. I don't think she was there when she was helped. So I think that he killed the wife, or he chloroformed the wife, but essentially knocks her out, starts this process. And I think the plan was that, this girlfriend was going to, put the, the kids and the wife in that car, and she was going to drive it up so that they could see it. And he was supposed to drive out and be on camera, leaving for work and putting things in. Okay. And I'm inclined to believe that I think he probably killed his wife in the house. I think the girls wake up, and they weren't necessarily supposed to wake up when they did. I think some of that's true. But I'm of the belief that she pulled into the back, the Parker car in the back, and that the whole deal was that she was supposed to be, um, driving, dropped off there. And I think her friend, there was a friend of hers that I think drove in her truck. And where I think everything went just absolutely awry is, I think they get there, he kills the wife, the kids are asleep. I think the plan was going to be for the kids to be in the car and get blown up, because I think ultimately what I had heard is they were looking up explosions, and it made sense to me. But I think the kids were going to be strapped in their car seats. They were going to be in Shanann's car. The plan was to get the phone open. He was going to leave. There was going to be a manufactured fight. He was going to pull up he was going to be up at the oil rig. That's why he decided to go up there. She was going to drive the car. Her car, whoever drove her there, was going to leave and drive off. I can't remember that guy's name. He was supposed to leave and drive off. And they couldn't get the phone open. Problem is, he'd already killed Shanann. The girls are there, and they have this mess on their hands. So I think it all ends up being like, all right, fine. I got to get rid of this body. So it was like, okay, I'll drive him up. And at that point, it just all went off. I think it just all went awry. Their plan went awry. They got a dead Shanann. They got the two girls running around. The girls have seen the girlfriend. And at that point, that's why he kills the girls. I just cannot believe he would kill his two girls the way he did, and have had the ability to stick his hands around their neck and do what he did. I think the plan was that, yeah, he was going to off his whole family, but it was going to look like an accident. He was going to get a big payout that was going to let him get out of debt. And in his mind, he would have somehow been able to rationalize it and been like, it was just this horrific accident. Shanann comes driving up, but I think they were planning to drive the car up there. He was going to get the hell out of there, and he was going to blow it up, and everything was going to blow up, and it would have looked like an explosion. Shanann would have already been dead. Her body would have been there. Her kids would have been there, and it just all went awry. So then it ends up being that he end up putting Shanann's car in the truck, or Shanann's body in the truck. The kids end up driving along, and I think he drives up there, and I think he's like freaking out, and he starts digging the hole, and he's trying to figure out what to do about the situation, and he realizes, I got to kill these kids, because if I don't, they're gonna implicate her, and I think it just all kind of flew off. But I think somewhere in there is the truth of the matter for Chris Watts, but I think it really does have to do with that there was a plan. I think the original plan that they had was going to be something along the lines of taking his family up there and making it look like an accident occurred. I just cannot imagine that he thought, yeah, I'm going to just off my wife, off my kids, hide them in oil tanks, and then I'm not going to get caught. I mean, how does he not think he's going to get caught in this? I mean, and why would he, doing it, and then he ends up in jail? So there's a missing component there. So yes, I think she was involved, but I don't think she was the person walking out of the house. I think he walks out to the house to get his car. That's on him. I always just saw that as him. I think the armchair detective said it looked like her, and he saw a woman and hair in her gait. I don't believe that was her. I think she pulled up in the back. I think he went in, and Shanann gets home. I think he lied in wait. I think he jumped on her and killed her. I think he calls, or I don't know if he calls or how they communicated. Correct. And then basically the mistress comes over, they pull up, and she pulled up in the back, and he lets her in the back. See, that's why she was coming in the back away from the cameras, and it looked like he was going to work. So then if all of this would have been perfected, he pulls off to work. They're texting. She's at the house. The phone's pinging at the house. He's pinging up, and they're manufacturing a text stream about their fighting because he tells her about whatever, and she says she's coming up to come confront him, and he's up at the oil field, and there was a leak. Remember, he's up there for a leak. So he gets up there for a leak. So in his mind, he gets up there for a leak, and if they drive the car up there and leave the car close to the oil drums, kids are in the car, or they chloroform the kids, or whatever they were planning to do with the kids, or maybe, whatever. They put them up there, lock the car. The kids can't get out of the car. She runs down, gets in his truck, and they, blow it. Now, I don't know if they were going to have the friend, who would have driven her there, may have even driven up to the oil fields. But at that point, they have an accident. He says, "Oh my God, my wife come up, and she came up and got all angry, and I told her not to come, and she came up looking for me and blew it up. She knew I was going to be up here, and I'd already moved to the next field, or who knows what their plan was. But I believe that was the plan, and it blows up, and because there's a leak, guess what? Now he gets all this money, because remember, they were in severe debt. So now he gets all this money. Enough money for them to go start their new life together. And then now, oh my God, this accident happens that kills his family. And yeah, who's going to think how's that going to have a causal link to him? just going to be his wife got mad, chases him up to the thing. Now he's no longer has to worry about the baby. He doesn't have to worry about the kids. He doesn't have to worry about the wife. And he pays off the house and pays off everything. And, with the insurance money that he gets from there, and goes on. And, I don't know what his plan was beyond that. But I recall seeing that. And I remember going through the discovery files and their stuff. But again, this was a situation where I think that obviously, however they saw it working out, it didn't work out that way. The kids were obviously alive in the driveway. I think obviously he puts them in the car. That's clear. They get in the car with him. He drives them up. So my belief is that either the body was transported up in a different vehicle, which might have been the vehicle that brought her over when they realized they couldn't get in the cell phone. And then he took the kids up and did what he had to do. But again, that's a horrific kind of evil. When you think like that case, it just bothers and disturbs me. But that's a case that I think that, again, there was more to it. And then when remember, the dogs didn't alert that there was a dead body in the house. So that's why I've always thought that maybe they chloroformed everybody. And their idea wasn't like I struggle with the idea that he was going to kill his kids. I think that would explain why the kids got up and you saw them. Now, obviously they got strangled. So that's how they ended up dying. It's what ended up having to happen. My only thing is, if he did have co-conspirators, did they follow him up to the, did they follow him up to the oil rig? Possibly. So did she do that? She might have. Yes, exactly. So you mean his mistress pretends she was Shannon Drive? That's what I think was the intended thing. But that was only going to work if they could get into her phone, which they could not, and that's why they hid the phone. I think it got haphazard, and he'd already killed her. Yes, so that's why I think she was dead. I think that they were going to either chloroform the kids or do something that was going to alleviate his need to actually have to kill his kids. He was just going to blow up his kids. But I think he maybe was a little more comfortable killing Shannon, but maybe he was comfortable killing his girls. I don't know, but I feel like the disposal aspect of the body, like the way he felt he was going to get away with this, it was going to look like it was an oil accident where the oil rig blew up. That's what I think. That's where I would go with it. So, yeah. But, so yeah, we, to conclude and summarize the Crumbley trial, I think that, I think, like I said, I think that this all hinged on the defense attorney not making it clear what was needed to get a guilty verdict here, or what was clear to get a guilty verdict, the hurdle they really needed to go. And she just, I think it was just a product of, it continued into closing arguments. It continued into everything. I think we can say there appeared to be an issue with preparation. There appeared to be an issue with having a command over case. And, so I think that, yeah. And also on this, it just came to mind. Remember, he didn't know that she had just changed her PIN code to the due date of the baby, but because he didn't go to that appointment, he didn't know when the due date was. See, so he didn't know that. So whatever he thought her PIN code was, it wasn't. And that was a fact that was a big deal, because that's what it ended up being, because that was in the police body cam of what's her name was there, and she said she knew it, but he didn't. And he didn't know it because he wasn't actively going to the baby appointments. And then he just found out, I guess they were supposed to do a gender reveal or something, but I don't even think he knew when it was, because he hadn't been going to the appointments. He hadn't really been taking a lot of interest in the child, which is horrible, I mean, but again, he had his own things. So I think that totally screwed the plan. But I think he thought, yeah, I know her plan. I'll get it. And either maybe even, I don't know if Face ID was hooked up on it. That's the only thing they kind of possibly throws a wrench in that, because they did have iPhones. So I don't know. Maybe the Face ID didn't work, or maybe she didn't have Face ID set up. I don't know. But they would have had the body there. So, but that was always my inclination. Or of course, it's Occam's razor. Maybe it's the simplest explanation. Maybe he is just a sadistic jackass, and he just literally concocted a plan in his mind where he said, I'm going to kill my whole family. Or maybe in a moment of absolute anger dealing with her, he lost it, he kills her, and decides, oh my God, I got my 2 kids who are witnesses, and somehow came to the conclusion that it would help him get away with it if he killed his daughters and drove them up and killed them. I think that's horrific. I don't know how he would have done it, even if he killed his wife. It's just unspeakable. But it's possible that could have been the case too. But I think there were some other things that made it possible that there was more to it. So my understanding, I kept this running because I had planned to go to the Adam Montgomery case. I think the only thing that happened in it was they charged the jury on the instructions. I think opening statements got moved to tomorrow. There's also a case I was going to follow for my next case, Adam Mead. It's a police officer out in Ohio who's charged with shooting a suspect, young man that would go on the subway, and he shot him 5 times. It was either 5 or 6 times. I believe it was 5 times, 4 in the back, one in the front. Claimed he had a gun. Problem is the gun got found inside the house. There was no body cam footage. And he's on trial right now. But it's day 6 of the trial. He just testified yesterday, and he was testified a little bit today. I'm way behind on the trial. I was originally going to try to get caught up on that, and then I thought, no, Adam Montgomery is starting. I'd also thought about going. There was a trial down in Florida that was for a little girl, but I was going to do that one because it was only a day behind. But then they didn't air day 2. Sometimes these news organizations will do that. We'll do that. We'll do that. So I thought, I was going to start covering that, and then they didn't end up airing day 2 today. So I said, well, I don't want to start day 1 and then not have a day 2. So I was thinking Adam Mead, and then I think I've settled on Adam Montgomery, or not Adam Mead, Jason Mead. So I think what I'm going to do is cover the Adam Montgomery case. It's an interesting case. It's about a father that's allegedly unalived his daughter, but they don't have a body. He's charged with abusing her. He's already doing 15 years for a gun charge that his ex-wife got him on for possessing, I believe it was possessing firearms as a felon that they found in a search. So he's already in jail. Interestingly enough, he waived his appearance during jury selection. It appeared he wasn't in court today. So it's got some interesting components. He says adamantly he didn't do this, and they don't have a body. There's some horrific details that were in the affidavit. So I think it'll be an interesting case. So that will start tomorrow, it seems. So we'll start that. I may go over and air the jury charge. I think, like I said, I'm very interested in the police officer case, but I just feel like it's 6 days behind. It's going to be hard to catch up. But we might try to take on that too as a secondary case, or at least watch his testimony, because he testified yesterday and today. So I might do that in a little bit. Come on, watch his testimony, and go from there. There's also a case I was going to follow. It's actually to the jury. It was only a day and a half unaliving trial. Guy shot his ex-girlfriend. I put up a video of his hearing. He was supposed to plead guilty, chose not to, and they put on like 8 witnesses. So I was thinking about doing that case too. That would be a quick case we could get through for the rest of today and into tomorrow, because it only lasted yesterday. They closing arguments today. There might even be a verdict already on it. I don't know if there is. But I figure Adam Montgomery's going to be the next one. So I appreciate everybody interacting on this case here. We will definitely be following the James Crumbley trial if that happens. Looking forward to that. I'm told that Tyrone Tucker has a new judge. I will be putting out a deeper video on that, but I am told there has been a judge assigned. And I am told that they have moved his case out of the Key West to the Marathon area. Perhaps they're searching for a different jury pool. I think they're trying to alleviate the concerns that he's being framed by the Bubba system. Still doesn't take away from the fact that case is very, very weak. So I'm told that the jury was 8-4 guilty, not 12-1, like the state tried to say. And I believe they're going to be attempting to do the ineffective assistance of count, or not effective, but they're going to be doing the motion to dismiss soon. So I'll be reporting on all that as that comes out. There'll be more details coming, so be on the lookout for that. But this concludes the Crumbley trial. I'm still very disappointed with the verdict, but I always respect jury's verdicts, even in the end if I disagree with them. And the nice part about our process is it will continue, and we will keep our eye on the appeal process here. And we will absolutely keep our eye on the James Crumbley trial, because I still think that's a very, very winnable case. And I will be very interested in seeing a contrast between his attorneys and the attorney she had. And we'll see if it has a different outcome. So, guys, in the meantime, until we talk again, like I said, I might go live here in a little bit with some portion of another case. I'll definitely be live tomorrow with the Adam Montgomery case, opening statements. But till then, guys, let justice prevail, and I'll talk to you soon.